Hello, everybody. Hello, Auntie M. So happy you could make it. Hello, Sir Philip from Mali, Victoria, Australia. Hello, Nana Laura. Hi there, crazy old Rexy. Y'all can hear. Hi, Rocky Lennon. Hey. You be nice. You be nice. No fighting in the PAWFURM. Well, come on, you. They're waiting. Yeah, come on. Don't let Billy intimidate you. You stop. You be nice. Somebody's jealous. Somebody's jealous of all the attention that Ava's getting. Come on, Ava. She's trying to hide, y'all. She's trying to hide. So hard. She's trying to be as far away from Billy as she can. Because he's right here. Come on, Ava. You're a good girl. You're a good girl, Ava. You're a good girl. Yeah, tell everybody about your exciting day of nada. I'm watching you, sir. You gotta get her giant box of treats out here. Her bacon, egg, and cheese health bars. I'm sorry, Billy. I'll make sure I'll give you your treats too. You're a good girl. Billy retreated before treats. Yes, the bacon, egg, and cheese. Maybe I'll switch it up here. I'll throw a pumpkin health bar in with the bacon, egg, and cheese ones. Cat crossing sign should still be there. It's always supposed to be there. Like, that's not something I turn on. It just stays on. I have heard, like, it'll only show up on full screen or on computer or laptop. So, you want that? Yum. So, like, if you're on a phone, you got to rotate it to the side or something. But it is there. It's a setting that's, automatically there. Woo! Hi. Now that the cat's gone, now there's no fear whatsoever. Oh. Let me see here. Oh, nope, that's not what I meant to click. Hi, baby girl. Okay, there. You got your treats? Oh, I'm sorry. I don't know what to do about it. I'll check it out though. I'll go on YouTube and see what the studio shows. But it's supposed to be there. Like, it's even on old videos. What? Yeah, hi. Can I do this now? She wants her treats, and she's already gotten them. You saw me give them to her. She's fooling with y'all. She's trying to convince you that she's, underfed and starving and, You know, she never gets attention, never gets treats. Yo, don't believe her. Don't believe her. Man, why has YouTube got to mess with me? Why? Why? Hold up. So, oh, thank you so much, Pam. Thank you very much. Ava's going to be absolutely stoked over that. You know it all goes to her, pretty much. All of it. Almost every bit. Like, there's really, that's not even a question. I am trying to see. Yeah, it's not there. I don't know why. That's weird. Yeah, I've got the little thing that says how many people are watching too. That's so weird. I don't know why they would just switch it out like that. I'll have to go into the studio. Thank you for letting me know. But I didn't do it. I love my cat crossing sign. Are you kidding me? That was one of my favorite things when Shane suggested it. And I was like, oh, I gotta do it. Because it was perfect. Oh, good. So that's the problem. Is that we have chat on. Is that what you're saying? Okay, turn off chat. And then rotate. Oh, he's right. If you turn off chat, it shows up. So that number must be just to let you know how many people are in the room that you're talking to. I don't know. I don't know why YouTube does half the things they do. But I do know Joey Bag of Donuts is right. Hi, Stephanie, sweetie. I'm so happy to see you. I got your message like 6 days late when you asked where I was a week ago, and I didn't see it. I don't know what I was doing that day, but it's been a wild month with my daughter graduating and all of her honors testings and the breakfasts and, all that other stuff that they do. But it should start slowing down a little bit, tapering off. Today was one of those days I literally spent all day editing because I told Chadaskadum that I would do a Kentucky docket for her. And they're all, and I mean all, like 3 to 6 hours a piece. Well, I'm not going to stream 3 to 6 hours. And so, how I go through and I cut out the, stuff that's not interesting and whatnot. Well, then, like I have to make my first round of cuts and then I have to go back there and make another round of cuts. And I did not get through it. All day, I edited it. I did not get through it. I've got so much stuff to edit. But I'm working on it. I really am. I'm hoping to have it done tomorrow. Thank you, Joey Bag of Donuts. Thank you so much. Did you get it, Pam? He's so good like that. I swear, he's got like Cupid's arrow of gifted memberships. That is so cool. I don't know how you do that. I don't. I have no idea how you manage to do that, like almost every time. That is so awesome. And Pam, I don't think I gave you your hello. You threw me off track by starting out with the super chat and puppy treats that I just like. My mind was blown and I spaced it. I'm so sorry. I love you. Thank you for being here. Even after you turned off chat? I don't know what to tell you. I don't like it. I don't like it. YouTube has been making a lot of really weird updates and changes and adjustments, and yeah, I can't keep up with everything that they do. But I just keep trying to plug along and hope for the best. Sometimes, as a YouTuber, that's all you can do. So tonight, I have a double feature Savsit. I tried to go for the trifecta. The day of his arraignment was last Monday, and I was not feeling well that day. Hi, Maligator. Great to see you, sweetie. Welcome back. Oh, yeah. It's not just Discord. I don't know. Everything's updating and everything's doing weird, funky stuff. I don't like it. Yes. So I caught a Sav sit today in SeaTac, one of my favorite courts, and I heard them mentioning his previous hearing, and I'm like, I gotta find it. So I went back and I found his previous hearing, and then in that one that they had mentioned that he had been arraigned on Monday. And so I went back to Monday, and that was the day that I didn't even get out of bed until nearly 2 p.m. And I didn't have it. I missed it. And they take them down every day, so I couldn't go back and get it or anything. So I only have 2. But 2 out of 3 ain't bad, right? That's what Meatloaf says. And I promise, it's worth it. He's goofy. We're going to have some fun tonight. Oh, come on, computer.
Hello,
Your Honor, this is Sylvester Evans. Is the court ready?
1 second.
did you get the letter I mailed in, Your Honor?
I did not.
Is the court ready?
Yeah.
Okay, I mailed the
One
letter.
second, Mr. Evans. So this is Sylvester Evans. It's 380312319, 480231898, 380655525, 380820191, 480472552, and 380549215. And I don't believe you were here, Your Honor, on Monday when Mr. Evans was arraigned. But Mr. Evans at that time indicated he wanted to represent himself, and he's also indicated that to me today. I did go over the waiver of attorney on pretrial and arraignment form with him, and explained it to him and talked about it. It sounds like when I spoke with him, because he's in custody right now, I know he wants to address his in custody status with the court, but I figured this needs to be addressed first. We discussed, if he's in custody, he needs access to certain things and that unlikely he can get. So he would want an attorney on standby to assist him with that. And I said that I don't have any conflicts, so I don't have any issues doing that if that's the case. But just so the court's aware. But I know he wants to address his conditions of release, but he also wanted to represent himself.
Okay, and I believe Judge Freund did do the jail calendar on Monday. So did you say competency was raised? I didn't quite understand that piece.
Oh no, that I was talking about the other person. Veronica Johnson was who I started to talk about.
Got it.
And then when Mr. Evans walked in, I just said, we'll get to that when we're done with Mr. Evans.
Got it. Thank you. Thank you for the clarification. All right, so Mr. Evans, so
Yes.
we have not yet done the arraignment, right?
No, it was done
It's done, so
Sunday. And the city doesn't believe there's any change in circumstances, so would object to defendant's motion
I
to
guess
release or
I
adjust
guess
bail.
Oh, thank you, Ms. Chenwell. I guess I just for my clarity, so this was on Monday and we set it again for today for what specifically?
Pre-trial and the
Oh,
tracking reviews.
okay.
Because the court said bail or bond, we set the pre-trials pretty quickly.
I
Got
would
it.
like to speak to Your Honor before we disconnect if possible, please.
All right, Mr. Evans, so it's my understanding that you do not want an attorney to assist you. Is that correct?
Like you said, if he could be on standby, I would like to represent myself because I invoked my right as a Aboriginal Native American Indian chief. That's why I asked if you got that letter, so I have certain constitutional rights that's afforded to me. In addition to that, I have a leg injury where I'm on crutches and they have me in 23-hour lockdown. I didn't do anything wrong. And I was trying to see if it's possible, based on the fact that I invoked my right as an Aboriginal Native American Indian chief, that I definitely will appear at every appearance if I could get a pre-recognizance bond, due to the circumstances. I assure you I'll show up, especially that I invoke my right as a Native American Indian chief.
And as the prosecutor stated earlier, Mr. Williams, I guess, what is the change? It doesn't sound as if you're noting any change of circumstance from when the court saw you on Monday and set bail.
I
Well,
can honestly say I don't recall defendant mentioning the Native American part on Monday, but he did discuss the other thing in quite more length than he actually even is today. So the court did have that before it. Now, as far as the other piece that he's presenting today, I state's positions that doesn't change anything and there's no proof.
I sent the proof in the letter, that I mailed out.
Wasn't provided to the city. I haven't seen any proof. And I would say
I'm-
that's not a change in circumstances.
I mailed the letter out
Like
on.
I said,
I mailed the letter out on Tuesday with the evidence, and the proof, invoking my rights as a Native American Indian chief. So I'll be working to get this case removed to the federal courts. I need to also file, in the federal courts, a notice to remove as well. And it's gonna be extremely difficult for me to do that from here in prison. So that's why I was asking if I could get a PR bond. I assure you I'll show up. I'm not gonna play with my rights like that as a Native American Indian chief. In addition to that, I'm in 23-hour lockdown with my crutches and it's affected my leg. I broke my tibia and fibula in 5, 6 different places. And the muscles and the nerves in my leg are getting worse because I'm not able to, rehab it like I'm supposed to.
and Ms. Chenweller, seeing that I wasn't here on Monday, what is the bail currently set at?
500 cash or bond on each of the 6 cases.
And does Mr. Does Mr. Williams have, what is his FTA history?
He does have a substantial warrant fighting history, including an active warrant out of Tacoma Municipal Court.
As I
Also,
said, Your
has
Honor,
not complied with court orders, and that he repeatedly returns to the airport. We have 4 pre-trials and 2 reviews involving those allegations, the same
And
allegations before the
addition to
court
that-
today. Has warrant failure history in pretty much every case.
What is his
City.
date of birth? I'm trying to find him on Jabs.
My last name is Evans, it's not Williams.
It
I'm sorry.
is 6/7/84.
And also, there's no evidence, that I was, trespassing each time I was there on valid personal travel. So this case lacks evidence, which is also why I asked to have it dismissed in the letter as well.
He went into that on Monday
And I-
as well.
And also, I never invoked my right as a Native American Indian chief. This time I did, so therefore I will not miss not one court date, I assure you. Can you
I'm
please?
not sure what you being a Native American chief has anything to do with you coming to court.
because I represent a sovereign state, and as a sovereign state, I have the right to have these cases heard before the United States of America, the Supreme Court of the United States of America. And in the letter, I put the details that prove what I'm saying, and also it should prompt everything to be moved to the United States Supreme Court, especially with some of the details that I put in there regarding my circumstances and what I have going on, which I'm sure Chief Justice Roberts can verify once the process or whatever, which I'm trying to go through the process now, but it's going to be very difficult to do this from inside the jail. But as a chief of a sovereign tribe that's federally and internationally recognized, I have the right constitutionally to go to, I have immunity, and I have the right as a sovereign state to have this cases heard before the United States of America. In addition to that, I have different types of immunity that I fall under as well.
All right, Mr. Evans, so I gave you an opportunity to speak just to make sure I understood exactly what was happening in this case, since I was not the judge on Monday. I have had an opportunity to review your criminal history, and I do see that you have had warrants in pretty much every case that has been filed against you that I can see in the state of Washington. So right now, I'm not hearing any change of circumstance that would give me any change in circumstance that would allow me to change the bail from $500 on each case. So that will remain as previously set on Monday. Additionally, we need to address the fact that you are requesting a waiver of right to an attorney. I will note that I don't believe that that is in your best interest. I think an attorney would be helpful to you. However, if that is what you would like to do, I want to make sure that you understand that you have 1, 2, 3, 4, and you have 4 cases that are pre-disposition, and it sounds as if you have 2 review matters, which means you've already entered into some sort of plea on those cases. But on your new cases, do you understand, Mr. Evans, that these are gross misdemeanors?
Everyone's facial expressions are just priceless throughout this whole thing. The confusion, the awe, the just WTF on everybody's faces is amazing.
Yes, ma'am.
And you understand that with that, you could potentially serve up to 364 days in jail and or pay a fine of up to $5,000.
Yes, ma'am.
Okay, you understand that you do have a right to have an attorney, have a lawyer represent you in all stages of these proceedings. And if you cannot afford a lawyer, that you have the right to request a public defender,
Yes, Your Honor.
and that a public defender, if you qualify, will be appointed to represent you,
Yes, Your Honor.
and that you may be at a disadvantage if you proceed without a lawyer.
Yes, Your Honor. As I previously stated.
Okay, Mr. Evans, I heard everything that you had to say. I just need to make sure that you understand the rights, and that you understand that you will be required to follow all the laws of evidence and court rules which apply to this case. Do you
Yes, Your Honor.
understand that? And that these laws and rules can be technical and complex, and that you may not fully understand them without a lawyer.
Yes, Your Honor.
Okay, and that you realize that by proceeding as your own lawyer, if you do not represent yourself in a competent manner, that you will not be able to obtain a reversal of a conviction on the grounds that you received inadequate representation.
Yes, Your Honor.
And are you aware of the risks and disadvantages of proceeding without a lawyer?
Yes, Your Honor.
And knowing that you still choose to represent yourself, knowing the risks, you freely waive your right to be represented by an attorney.
Yes, Your Honor.
So you are waiving your right to be represented by an attorney.
Yes, Your Honor.
All right.
And also, would you be able to look into a oral motion to dismiss due to lack of evidence at this hearing?
You would have to do that, Mr. Evans. You are acting on your behalf as an attorney. So that is a motion that would need to come from you and or your attorney.
I actually mailed in a letter. I was trying to see if the courts received that letter because that was in the letter that I mailed.
Okay, we do not have that letter at this time. So we're gonna set this matter for another pretrial hearing.
Could you set it for sometime next week when you guys get the letter so you can understand everything I'm saying?
I believe we
Better.
will have to set it in due course in regards to the court's availability.
I don't think having the letter is going to help them understand any better.
Yes, Your Honor.
May I inquire if a copy of that was sent to the city?
I mailed it off to the clerk's office, and also, Your Honor, could you please put on note that I requested that that letter get sealed due to the protection of innocent life, not only mine, but others that's at stake due to the information I revealed about me being a Native American Indian chief and the evidence that I've revealed in it. That, could you please put on note that I asked that it be sealed immediately?
And again, Mr. Evans, those sort of things need to be done in writing to the court. Mr.
I
Iron, do
did.
you have any concerns about competency?
I do, but I'm hoping that if the court sets a hearing next week, I think either on Tuesday or Wednesday, perhaps that letter will have come in and it might answer.
Okay, so for right now, I did sign the waiver of attorney, but I am going to allow counsel to remain on standby. Let me see when's the next time we can.
And Your Honor, would this be in custody or out?
This is in custody.
Thank you.
Morocco.
All right, and Ms. Garza, what?
Next Wednesday would be better than Tuesday since Monday's the holiday.
Oh, yeah.
So we are setting these matters for a pretrial conference on Wednesday, May 29th. Ms. Garza, do I have to go into each individual one and hit the pretrial button?
Yes, or the review button for that case.
I'm not sure which ones are the reviews.
The case ending in 1-9 is a review and ending in 2-5 is a review.
Thank you.
So on the order, it's the top one and the very bottom one.
And also, Your Honor, I would like also to put on note that I mailed the letter off on a blank piece of paper and I numbered it. If it's kind of difficult to read, you might have to put something on each line because due to the circumstances, that's why I had to mail the letter off. I mailed the letter off.
Huh?
Because I was in a tank to where I didn't have access to anything. They had me in a restrictive tank while I'm on 23-hour lockdown. And I have no access to the law library or nothing.
Did you try the library?
All right, so we are setting these matters for May 29th at 11 a.m., all matters. If there's nothing else to address, this concludes this matter.
Just want to note for the record that the city is going to object to the motions being heard if we don't receive copies.
Did you hear that, Mr. Evans?
They're gonna, no, ma'am, could you repeat it, please?
The city has stated, since you are acting as your own attorney, that if they do not receive the information that you've provided to the court that they will be objecting. It is a responsibility of you or your attorney to provide any information to the court and to the prosecutor.
All I can do is mail the letter off. I mailed it off. I don't know if the guards kept it or if it gets lost in the mail. I don't know. I can remail the letter, or I can rewrite it and remail it off. But I mailed the letter off. I definitely sent it off, and I have the guard that picked it up. I have documented the guard that picked the letter up. So I definitely mailed it off, and it should be on camera that I handed the letter to the guard.
All right,
Saying
well,
it's entitled to an opportunity to respond. We would need it at the very latest by Monday. I mean,
I
if we're
mailed
setting
it.
it for Wednesday.
I mailed the letter off Tuesday. So
Okay,
it may get
well,
there today or tomorrow. Because it shouldn't take no more than 1 or 2 days for it to get right there to SeaTac Court. I mailed it to the 4800 188th Street, and I put on there to the clerk. I attentioned it to the clerk, so that letter shouldn't take that long. If it doesn't come to you guys, that means it got lost in the mail or something like that, and I would have to rewrite it. I do have a rough draft of it. So I will be able to read it out to you verbatim Wednesday if you like, if you haven't received the letter by Wednesday. I did keep a rough draft of the letter, so I could read it out to you verbatim. Or if you don't mind, if you could give me a second, I can go and get the rough draft out of my cell right now and read it to you.
no, we are not ready to address that today, so we will
Okay.
address these matters again on Wednesday, May 29th. All right, so this concludes this matter. Bail, as I stated, will remain as previously set, as well as all previous conditions of release.
Thank you. Then we have to put the bail amounts in.
Yes, that's what I am
Thank you.
doing, and it's 500 each case, right, Ms. Chenmuller?
Yes.
Okay, thank you.
Could I get a copy of the paperwork, please?
You will receive a copy of the paperwork. All right, this concludes this matter. Have a good day, Mr. Evans.
Same here, God bless. Paperwork you gave don't
I don't have that case on my calendar, so I'm just, we'll get there when we get there. Okay.
Your Honor, this is Sylvester Evans, 3A0312319, 38549215, 3806555525, 38820191, 4A0231898, and 4A0472552.
Round two.
Mr. Evans, I think this court heard him initially, but then there was court heard him, I think, last week. Mr. Evans has indicated that he'd like to represent himself on this matter and have our office as standby. I think the court granted that motion, but set this hearing to today because Mr. Evans indicated that he sent a letter to the court that had some requests in it. I don't know if the court received it and if a copy was provided to the city. I have not seen it.
I have not seen it. I looked in the court file earlier today and it was not there. Madam Clerk, do you know if we've received it?
I don't know why you guys haven't received it. Also, can I ask that this hearing is on record and that everything is being documented by a court reporter, please?
We do not have a court reporter. We're creating an oral recording though.
Okay, so will it be on record and will
Yes.
will it be able to be reviewed by federal judges if it gets to that or whatnot?
Yes.
Okay, I can read a copy of the letter. I mailed the letter out. There's no reason it shouldn't have reached you, but the letter had very personal and sensitive information regarding my sovereignty as a chief of a sovereign tribe that's federally and internationally recognized. I don't know why that letter didn't make it to you. I mailed it out last Tuesday, so it should have definitely gotten to you guys by now. I'm having issues with getting to the law library. I've been in the hole. It's like almost impossible for me to legally defend myself with the conditions within the jail. One thing I would like to ask, especially being that you didn't get that letter and I invoked my rights as a sovereign tribe, chief of a sovereign tribe, that if possible, you can give me a PR bond so I can properly get everything to you and make sure it's filed in the courts. I assure you, being that I invoke my rights as a sovereign tribal chief, that I will appear at court dates. I won't play with my rights like that. I have too much to lose. And I have a leg injury. But the main thing is my legal part and the getting the proper defense, and then the mail that I'm mailing out, it's not even getting to you. So I know I'm gonna have an issue defending myself from the inside of this jail. If you could do that for me, humbly, respectfully ask that you give me a PR bond so I can at least properly defend myself, especially that I invoke my rights as a tribal chief.
I believe we've already had multiple bail hearings. I'm sorry, Madam Clerk, you were saying?
I was just gonna say that there was a letter that was faxed in that we received yesterday, and I just forwarded it to all parties.
Okay, thank you. I'm going to take a moment to look at that then. I didn't see it in the file.
In addition to that, I introduced evidence that will exonerate me.
Mr. Evans, I can't read it and listen to you at the same time.
I'm sorry, Your Honor. Also,
Sir, I can't read and listen at the same time. I read slowly.
sorry.
It did take her quite a while to read through the letter, y'all.
Okay, I've read your letter. You've already had at least one bail hearing. I remember it. I have not heard any change in circumstances such that you're not entitled to a second bail argument. Bail remains as previously set, $500 per charge. What tribe are you enrolled in?
All of that, I don't want to reveal that information because it's private. That's why I invoked also the Peace and Friendship Treaty between the United States and Morocco, in which I do qualify for that. And also you can contact the Embassy of Morocco.
No, so I'm familiar with that treaty, and it is a trade treaty. It has nothing to do with your right to commit crimes anywhere you feel like.
No, ma'am, it has nothing to do with me committing crimes, but they will vouch that I am royalty, and Morocco has granted me as part of their royalty, and they will vouch for me, I assure you.
You can't be a royalty in Morocco and a Native American. That's not possible.
I assure, if you look at the evidence that I submitted, I assure you I am.
I received no evidence. I received just your letter.
Right.
So I'm not going to.
And
I'm
the
not
letter.
going to grant your motion to dismiss.
Okay.
What are we doing?
Okay. And I submitted evidence in the letter.
I'm not denying. I'm not granting a motion to dismiss.
I understand, but I submitted evidence in the letter as well.
I've considered your letter, and I'm not granting your motion to dismiss.
I understand.
Okay, what are we doing?
What about the evidence?
What do you want me to do with the I don't have any actual evidence. I have your statements.
Right, I submitted evidence in the letter. If you read it, you'll see that I submitted a civil case as evidence.
You submitted you mentioned a civil case. I don't see the civil case. I have no access to this case.
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me. And in addition to that, it will prove everything that I'm saying to be true.
I don't have that case, sir, is what I'm telling you. All I have is your letter.
Right. In the letter, I submitted civil case 24012 out of
Sir, I don't have that case in front of me. I don't know what's in it. I have no access to it. All I have
You have
is
to retrieve it.
I have no way to do that.
You have to
That's your
contact the
job.
courts.
Sir, that's your job. This is your case. You represent yourself. It's your job to put your case together. It is not the court's job. I ethically cannot do investigation on my own.
No, I'm not asking you to do an investigation.
You are. You're asking me to go retrieve something. That's an investigation.
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me.
Then you have to actually get that case and put it before the court.
It's impossible for me to do that inside jail.
You have a standby counsel, perhaps you can talk to him about it.
You should get a lawyer, dude.
Are you gonna be able to retrieve that case for me?
1 second. And Your Honor, I can make the records request. I don't know if it's going to have any luck receiving it. I mean, based on the information that I have.
The
Okay.
case has a seal on it, and you're gonna have to get permission from the Chief Justice Roberts to get the seal broken.
I don't understand what the US Supreme Court has to do with a Louisiana state case.
Because it holds my rights as my constitutional rights and privileges as a chief of a federally and internationally recognized tribal chief,
Does it
in which I
though?
represent a sovereign state.
Okay, so what are we doing today?
According to the letter, if you're not gonna dismiss it, I asked that, in the letter, I requested that you file a motion of discovery.
I can't file any motions. I'm not an attorney. I don't represent you. I don't represent the city. That is not my role.
Okay, and you said you're not dismissing due to lack of evidence.
Correct. I have read the police reports and did find probable cause to detain. And some of these cases are in review status. They've already been resolved and found guilty.
Okay, and also in those review cases, I said if the review,
Sir, I'd really like to focus on what we're doing today. I've denied your motion. We need to move on.
yes, ma'am.
Okay, so what are we doing today? What's the plan going forward?
The plan going forward, I would like a fast and speedy trial by jury. I would like a motion for discovery to be filed. I would like a motion to suppress.
Sir, you represent yourself. You have to file those motions. Nobody, you asked to represent yourself. You've got, Judge Rose Akins granted that. So it's up to you to file those motions.
Okay, I just received the paperwork from Mr. Iannetti today on the format to file those motions, so I'll have those motions mailed out tonight.
Okay, perfect. All right, so we're setting this for trial, is what I'm hearing.
By jury.
Okay, so only the pretrial cases are going to be set for trial. I see the pretrial order has all the case numbers on it. Or does it have only the pretrial one?
Oh,
Okay.
I just clicked on it to give them an example of that order as well.
No, I think you've got all the right ones on here. 1-5.
And I also asked that that letter be sealed due to the fact it has sensitive information on there regarding me and
You
my
have to file a motion to seal it, sir. I'm sorry, but this is why it's best not to represent yourself if you don't know criminal procedure. There's a whole process to having something sealed. I have to make certain findings. I don't have that motion in front of me.
Okay, I requested it in the letter, but I'll file a motion as well.
Okay. But I'd encourage you to read the Bone Club case so that you can understand what the guidelines are for sealing.
I haven't received any of that information, and also I need access to the law library, which is like, I don't have any access to the law library.
That's something you'll have to talk to SCORE about. So has any discovery been provided?
I gave them the narratives.
Police reports, that's it.
Ms. Chenweller, is there additional discovery?
We can certainly check.
Yeah. Is 14 days sufficient?
Yes.
Will the city, first of all, is there a motion to join and consolidate these cases for trial?
Yes.
Any objection, Mr. Evans?
Yes, I do have an objection.
So then you realize it'll take roughly 4 months to try these cases.
Will I be sitting in jail the entire 4 months, or is it 60 days still?
The problem is we can't try, if you're not gonna agree to try them simultaneously, I can't guarantee you they'll all be tried within, we only do jury trials 1 week out of the month.
But my question is, will I have to sit in jail 4 months or 60 days?
Potentially 4 months. I can't rule that out. And I'm not trying to pressure you into agreeing. I'm just setting out the facts. You do what you want to do.
We can look for it. I just explained what joinder means and the benefits and disadvantages of joinders.
So, Mr. Evans, what do you want to do?
I want to do them all separately.
Okay. We'll set them, here's what I'm gonna suggest then. I'll put this out to you guys. You tell me what you want to do. Set them all in the June term. And then whichever one goes, but we'll have them all set so that it'll depend on who's available and such, okay? But they are not joined that unless somebody files a motion to actually hear it, but as of now, nothing is joined, okay?
Yes, Your Honor.
So the readiness hearing will be on June 12th.
Sit out here.
And jury trial beginning the week of June 24th. Is it the 24th? It's the 24th, right? Madam Clerk, I think. Are there any custodial statements being offered by the city? Or I'll check a 3-5.
I'm sorry.
Potentially, yes.
I got kicked out of Old Court as soon as I tried to move. Yeah, the jury trial week is the week of the 24th.
Perfect, thank you.
Mhm.
And we'll have a hearing on admissibility we'll have a 3-5 hearing. That's a hearing about any statements you may have made, Mr. Evans. And a hearing on admissibility of any 911. I don't know whether there is or not, but just in an abundance of caution. Will you be filing any motions to suppress under Rule 3.6?
I'll be filing motions to suppress and subpoena.
Are there additional witnesses you'll be calling?
Yes, ma'am. I would like to subpoena the airport director or the operations airport so I can have those guys verify that I was there. The reason I was there is legal airport business.
Ms. Tenwaller, is including SeaTac airport operations sufficient to put the city on notice of who the defendant will be calling?
No.
She is not going to make this easy for him. And why should she?
Okay. What would you accept? I don't know how to put this because I don't think Mr. Evans knows who this is right now.
I believe the onus is on
director
the
of the
defendant
airport.
if he wishes to identify and subpoena that individual or individuals.
Okay, so as soon as you figure out who it is, you have to put the city on notice.
Lance Little, the managing director of the airport.
Okay. SeaTac Airport Managing Director Lance Little. I've included that.
Got it.
Will you be offering any affirmative defenses?
Is that a question to me or the?
Yes, it is. It is.
What's your question again? I'm sorry.
Are there any affirmative defenses?
Could you reword that, please?
Perhaps Mr. Ainati can help.
Yes, 1 second.
Yes, ma'am, I do. I will be providing an affirmative defense and the right that I was a law-abiding citizen at the airport.
So I think that's general denial. That's not an affirmative defense.
Time for an education.
But also that I was a passenger of a business that operates legally in the airport, of a charter bus company that legally operate. I was a customer of a charter bus company that legally operates in the airport.
So still, that's just general denial. That's saying I didn't do it. Not an affirmative defense is saying you did it, but there was that you were allowed to do it.
Right. I was at the airport, and the reason why.
So that is general denial. That is saying there was no crime that was committed. That's what you're saying, right? That you did not commit any crime.
No, I'm saying that I was a customer of the airport.
Right, which would not be a crime. It's
Correct.
not an affirmative defense. An affirmative defense would be saying, I trespassed, but I had to because I was being chased by someone and I ran into the airport for safety. It was necessity is an affirmative defense.
Okay,
Lawful use of force is a defense.
in that
Just
case.
saying I didn't do it, I was allowed to be there is not an affirmative defense. It's a defense. I'm not saying that it's not a defense. I'm just saying it's not technically an affirmative defense such that you have to put the city on notice.
Okay, according to your definition, I guess it's not an affirmative defense, but once again, could they close the door so I can make sure I'm hearing? Can I re-verify that everything is being recorded and that everything's on file? And I would also like that a court reporter be present for all future hearings and possibly for this one as well, if possible.
We will not have a court reporter. We are not required to. We are not a superior court. We don't have a budget for that. We record everything. Everything is recorded. But we do not have a court reporter. We do not have access to a court reporter, and I'm denying that request.
Yes, ma'am. And then also, could I file a motion to appeal that?
You have to actually file it. You can't, you don't need my permission to file a motion. You can just file it.
I mean, a notice to appeal, I'm sorry. So I would get that information from Mr. Ionetti because I don't have any access to the law library to get these motions or notice of.
Sir, you have to have a basis in law to request that. I can't imagine, we are not courts of record in that sense. Like a superior court. We do not have court reporters.
I understand, but I feel my constitutional rights are being violated.
So there is a recording of everything. Everything can be recorded and transcribed, but we don't have a real-time court reporter.
Okay, what's the difference?
I can.
I'm ready, Your Honor.
Okay. And it looked to me like what is current speedy in custody, Ms. Chenweller, do you know?
719.
Thank you. All right, Mr. Evans, bail remains $500 each case. We'll see you back here, each count rather. We'll see you back here on June 12th at 11 o'clock in the morning. Stay in touch with Mr. Ionetti. He can help you.
Ms. Judge, Your Honor, my bail was raised. Is there any explanation for my bail being raised? Some of my cases was $250. It went from $250. Yes, ma'am.
Oh, I'm sorry. Did I mean I just said that I changed it right now? I see that.
It was changed by the previous judge. It was raised to 500. She went just off the notion of what the lawyer said, which was inaccurate. And then the inaccuracy was passed on to you as well. And then you were about to redouble down on it.
All right. Thank you for pointing that out, sir. I'm restoring bail to $500 per case.
You mean $250 for some of the cases? And
well, it's $250 per count on cases that have 2 charges.
all right, let me take a look at the paperwork I got and I'll let you know which one said $250 bail.
Yes, Your Honor, I believe that the last hearing that it was pro tem judge and she set it at 500 per charge. And I think she misunderstood that when Ms. Chenweller advised her, it was supposed to be 500 per case.
Correct.
Okay, for a case ending in 2319, that was $250 bail.
No, see, there are 2 counts. Look down below it. There are 2 counts. There's 1 count of criminal trespass in the 1st degree and 1 count of making a false statement. Both of them are $250. It's 1 case.
Okay, so you combine the 2 charges and it comes up to 500. I got you.
Correct. So it's 500 per case, but I'm restoring it to that. I believe there was a Scribner's error in the last order. And I thank you for correcting me, Mr. Evans, or pointing that out. So it is now, so on the case, and similarly, the case ending in 525, that's the last case. There are 2 charges on that case as well, and it's $250 each charge. Okay. So then,
So was I right or wrong?
you were right.
I know, we are all shocked.
I mean, I put it back the way it was, 500 per case. So we're setting readiness on 191, readiness on 898, readiness on 552, and then readiness on 215. And then review on 552, right?
And you say you set a trial date too as well?
Correct. Readiness is on June 12th, and then the trial will begin on June 24th.
Okay, and I'll have trial for all 4 cases on the same day or?
We can't possibly do all 4 in one day. We're good, but we're not that good.
Gotcha, so,
One second.
So we have 2 case numbers tracking as reviews, correct?
Right, I'm for some reason having a lot of difficulty. 525 is a review. And which is the other review?
2319?
2319. Oh, it's not on here then. Oh, 2319, right, that's a review. And 525, right? Or 552 rather.
25. It's very close to a
Oh, they're very close, aren't they?
the
Okay. I see.
end. Yeah, but the pre-trial won't be 4A. The review would be 3A and then it ends in 525.
That's review. 898 is a pretrial, right?
It should be, I believe it was listed as arraignment, but
I think
believe
it's
defendant was arraigned.
right. I agree. That's what my review of the docket. And 191 is a pretrial. And 552, that's what's was getting me so confused. There's 525 and 552.
Mhm.
And 552 is readiness. So okay, and I have 2.
and also the letter that I sent you, it's gonna be on file for the public to see all the information I have in there?
Until I receive a motion to seal and we have a hearing on it, yes.
Did you read the backside of it as well, what I
Yes.
said? Okay,
But sir, so this is why I'm encouraging you to look at the Bone Club case, because that sets out the criteria by which a court can seal a document. It's not, I can't just seal it because I feel like it or because you want it sealed. There has to be a
it's
justification.
a matter of national and homeland security.
You can't just say that. You have to show me why it is.
Because it's an investigation.
So again, you can't just say things. You have to, I need the whole story, not just little bits.
You
And
would
just so
have,
you're aware, we are streaming this hearing live on YouTube before you go any further than you want to.
right, so my whole life is in danger at this moment because of this.
I'm having trouble getting one to take here.
He's a soft idiot.
I clearly wrote in a letter that I'm connected to an investigation that is a matter of national and homeland security.
But you can't just say that. You have to show me the whole thing. I can't just take your word for it that that's an issue. You're muted. You're muted.
I gave you the evidence to prove what I was saying as well.
But you didn't. You just said, I have this thing. You didn't, I don't have the thing. I need the thing.
I gave you the evidence in civil case 24012 out of St. James
Okay,
Parish,
we're
Louisiana.
circling, sir, we're just circling back to things. I do not have that case in front of me. You have to present that case to the court. You can't just say there is a case.
So I have to do it in a motion form, or do I have to, for me to physically get a copy of that, it's impossible for me to do it. My lawyer probably can do it, but it's impossible for me to do it from within inside.
I understand, and we had this discussion at the beginning of the hearing. and you've talked to Mr. Ionati about that. I can't do any investigation. I am not your attorney. I'm the neutral party. I'm not the city. I'm not you. I will do no investigation. That would be, frankly, I could be sanctioned for doing that. It's up to you to present evidence to the court. It is not the court's job to find evidence.
Okay, in the letter, I did present it as evidence.
It's not evidence, it is just claims.
All right, so I actually have to file a actual motion as evidence and
It's not the motion, you have to file the evidence, the thing itself.
you mean the actual physical copy of the civil case?
Yes, that is exactly what I mean.
I don't have the actual copies of the civil case in front of me due to the fact that I would have to call the courts to get it. And I cannot do that from inside of this jail, and they will not fax that to me from the inside of this jail.
Try the library.
Okay, so we're having the same conversation over again. You can talk to Mr. Ionati about this. But I can't, there's just a limit to what the court can do. All right, thank you, sir. We'll see you back here on June 12th. Thank you.
Yeah, that's all we're gonna see today. Mr. Stour has refused. I think he's the last one.
Okay.
I'm good to go.
Yeah.
Thank you.
All right, probable causes previously found on, I found probable cause on Sunday. Bail remains $500, and we'll try again for tomorrow. All right, thank you.
Thank you.
He did not want to leave. Oh. Yeah, I don't think it works like that. I think it's gonna take a few more hard life lessons for this, Indian chief. What was it? No, he's a Aboriginal Native American Indian chief from Morocco. He's royalty. I do. I am so happy that you enjoyed it. I enjoyed it as well. I was so excited. I was just, speeding through trying to see if I could find anything worth streaming because I really had not had a whole lot of luck. And all of a sudden I'm like, no way. Did I just find this? And I was like, okay, I've got to go see if I can find the others. And so I went back in my archives, and thankfully I had the one other. I did not have his arraignment. I was super sad that I did not have the arraignment. I even contacted Lone Wolf LaSalle, and I contacted people in court, and I was like, you guys, please help me out here. I want the trifecta. But neither of them had it either. So we tried. We tried. The little LawTube YouTube community tried coming together for a moment, but unfortunately, none of us had it. Yay! Yay, Brian Bugs, finally! That doesn't happen for you often. I'm so happy you had a good day, buddy. You deserved it. Kia ora, Yvonne McLaren. Ooh, that'd be fun. Soft sip party. What would be the party favors for that? What do we decorate for a soft sip party? What do we use to decorate? Well, hi there, kitty kitty. Hi, Earl. I see an Earl butt. Earl. Is there a bunny in the yard? Is there a bunny rabbit in the yard? Yeah, it's a lot of work for the court. Oh my gosh. I love that second judge. I love the first one too, but I absolutely love the second one. I'm familiar with that treaty, and that's regarding trade. It has nothing to do with what you're saying it does. And then the the whole you can't be royalty and a Native American Indian chief. That's not possible. That's not a thing. Like, it sucks when the judge actually knows something. How are you supposed to get away with anything? Oh my goodness. I have got to make one. Oh, that would be so much fun. I have got to make one in honor of him. I have to. I will be making a fez hat tonight. It is a thing. It is arts and crafts time coming up. Should I stream it? Should I stream making my fez hat? Okay. Oh my. Oh yeah. I can't just give to one. And I can't hide the comment because, my gosh, you guys. I was really just going to give Earl a treat, but I told you I'm not allowed to. I'm not allowed to just treat one kitty. And I can't take turns with the treats. They've got to both have them at the same time. Not spoiled at all, are you? My gosh. Kitties. Yeah, trespassing at the SeaTac airport. But his claim is that he has a right to be there because he was a passenger on some charter something or other. And so you can't trespass a paying customer. That's his legitimate argument. Oh, I bet there are. When? He can show you the world. Yeah. Something tells me. No, Stephanie was saying something about he has sued multiple towns or something like that. I don't know anything about that. That must have been in the arraignment hearing that I missed, maybe. Yes, Auntie M, I have felt as also. I do have felt. Oh yes. Shining, shimmering, splendid. Yes. So the fez hat will have to be shining, shimmering, and splendid. Yeah, well, they call it a grassroots movement, but yeah, it's I don't even know. Sav Siddery is just, but now that Sav Sit has such a negative view, now they're all claiming that they're not sovereign citizens, but he actually said it a couple times that he was, part of sovereign tribe or something. But I want to know what his claim is on that whole national security thing, and his life is in danger and all that other stuff. Oh my God. I know that one. Oh, I know that one. Sav idiotry. I call it Sav Sidiot. He's a Sav Sidiot. Yet national and homeland security. I'm sorry. I got it wrong. The tassel's gonna have feathers. It's gonna have feathers. I will make mine with feathers. It's gotta be special, like as special as him. I gotta go back. How many people are in his tribe? I put that up on the screen for a while. I just don't have the answer. Yeah, that one was up on the screen for quite a while. I just don't have the answer. No squirrels will be harmed in the making of my fez. What's wrong with you, Brian Boggs? I love my squirrels. They're my best friends. There we go, Catherine Gasson. There we go. Oh. Neither. Although I do have guinea hens feathers. Those are actually really pretty, black and white spotted. Hold on one second. I'll be right back, y'all. PAWFURM, come entertain people. Ava, entertain people. She won't. Hold on. Let's see. Do I have anything to put on while I go in the other room for a second? Give me a second here. I don't think I do. I really don't. I really don't have anything. I don't have anything. That sucks. Just the replay crew minis that I've been making. Oh, Ava. All right. Oh, I have lots of peacock feathers. Lots of them. Well, that's why you have to put some out with the expectation that it's also for the squirrels. You don't put out birdseed just for birds. Like, that's so selfish. You put it out for the birds and the squirrels. Like, seriously, what are you going to do next? Be like, oh, the blue jay got into the birdseed, and I only put it out for the grackles. The starlings are coming next week. What are the robins going to eat? No. You put it out for all wildlife. Oh, if only, if only. No, because I just realized that I have to, I've got, okay, I used to make dream catchers, like for serious, for real. I can make dream catchers. It's one of my talents and they're beautiful. But I have a giant plastic bin of feathers of all different types. And then I have a tall plastic, like, you know, the cereal containers. Yeah, it's one of those filled with feathers, upright so that they didn't get damaged at all. And then on the front porch, I have a couple bags of peacock feathers. So I've got feathers all over. So, you know, the funny thing is, I have one of my very close friends. He had his parents. They were going outside for their morning cup of coffee, and there was a bear that knocked down his bird feeder. And they just sat at the picnic table and watched the bear eat the bird seed. It laid down on the ground and just that's it. Just stuck its tongue out and pulled it back in. That's it. And yeah, they just sat on the picnic table and watched it. Yeah, I actually I make the ones that I make are made with real deer antler. And then, you know, they've got like jade or, you know, some mineral that has, you know, healing properties or something, you know, in the middle. They're very, very pretty. Oh, I bet. They're going to be all kinds of helpful. Hi, baby. Hi, baby girl. Yeah. Oh, sweetie. Do you have a Native American casino near you? Because oftentimes they have handmade real dream catchers made by elders or tribal members. Here we have the Ho-Chunk Nation. So and they do a lot of like booth setups for every event, pretty much, where the elders can sell their wares. They have so many beautiful, you know, beaded stuff. Like they make gorgeous bracelets. And then blankets and just absolute gorgeous stuff. What are you talking about? It's the GM of WWE next, Ava. What? Sorry. I don't follow wrestling. I don't speak that code. I have no idea what you're talking about. That is actually backup counsel. So that's the defense attorney, but he's not allowed to defend him because he wants to be pro se. So he's on his backup counsel. And he does refer to him a couple times. Very rudely. Yes, she did. That was hilarious. I love that judge. I do. I love that judge. Yeah. Sucks when they actually know what you're talking about and they can call you on your BS. Huh. I'd put good money on that one. That's a fact right there. I don't know what tribe he's claiming, but none of them claim him. Aww, that's so sweet. That is so sweet. All right, guys. Unfortunately, that's the only clip that I have because I spent literally all day trying to edit that Kentucky docket and I did not get through it. But I would like to go over to Discord and play some games with you guys. Who's up for it? Who is up for it? I would really like that. I mean, we can. You know what? We can. That's a good idea. Let's do that. I had pulled up, actually, I had pulled up the Bone Club case explained because she had mentioned a couple of times to read the Bone Club case. So presents a matter of first impressions regarding a trial court's responsibility to protect a defendant's right to a public trial under Article 1, Section 22 of the Washington Constitution in the face of the state's motion for full closure of a criminal hearing. It would take a very long time to read all of this, so I'm not going to do that. But I will put this link in the description of the stream. I think that's a fair compromise. There's a link. Philippines posted it earlier, and we'll make sure to post it again. But you just register for it. But Rocky Lennon has requested the Reno docket, so I'm gonna put Reno docket on because I meant to go back and watch them earlier today, anyways, and I really like them. They're fun. It wasn't our dad judge today. It wasn't dad judge. I thought it was Reno 1 today. Oh, that was 2 days ago. Let me check something out here, guys. Just bear with me. Okay, nothing on that one. Well, we're going to go to today's in custody jail arraignments.
Okay, so I'm sorry to see you there in jail. Are you doing all right?
Yeah.
Sorry.
Thank you. Good morning, Judge Champagne. I'm going to go ahead and defer to you, sir, so you can get to your early morning docket. I'll just stand by.
Thank you, Judge O'Neill. I appreciate you letting me jump in here. Let me talk to Richard Harder, please.
He's on his way, Judge.
Morning, Your Honor.
Hi, Mr. Harder.
How we doing?
Hold on just a sec. Let me turn my volume up here a little bit. I can't quite hear you. Can you speak up a little bit for me?
Yeah.
There you go. Okay. So I'm sorry to see you there in jail. Are you doing all right?
Yeah.
So anything you want to talk to me about?
No, I mean, the only thing I can say is I don't know why I'm in here because I'm using a legal substance. I used it before.
Nope.
Before judge, before the 9th, and we met with you on the 9th, found out you did not want to have it used. I stopped using it. And that's the outside. That's all I have to say for you. That's
All right. Well, and all I have to say to you is, excuse me. All I have to say to you is that we talked about kratom, and the kratom was not going to be an approved substance for you to use while you're out on pretrial with me.
I did not.
I talked to you about my concerns with kratom is that you can buy it at any gas station or smoke shop or whatever. We have no idea what is actually in it other than the kratom that we're testing for. It could have any number of things. And it enforces my concern that what you're doing is that you're using kratom as a substitute for opiates. And everything that I see from you today tells me that you're resistant to that belief. I can't prove that one way or the other. What I can do is that I can make sure that if you're out there in the streets and that if there's a possibility that you're driving, that you're not whacked out on kratom or Suboxone or anything else like that. So you've been in jail for 2 days. I'm hoping that that gives you enough time to figure out what's going on. Mr. Altum, anything you want to say as far as this goes?
Your Honor, I saw numerous of these violations. I hadn't seen Mr. Harder prior to this, but I don't know if
Can you not hear it?
we've adjusted his bail or anything like that.
No, we didn't adjust his bail. I just took him in. He showed up for court and he did not look well. We tested him and he tested, he came in with that previous positive test. So my goal is to have him tested on a regular basis for the kratom along with everything else.
Okay.
He's already set for trial on July 8th. So I'm certainly willing to accept any sort of recommendations from counsel. My plan is to put him on enhanced supervision and see where we're at from there. Anything that I'm missing on that?
No, Your Honor, if he certainly from the city's perspective, since he's been in a couple days, if he comes back positive any more time, we'd probably request an extremely high bail.
All right, Mr. Loomis, anything to add on this?
Judge, what he explained to you is what he explained to me. I think what you're proposing makes sense.
All right, Mr. Harder, here's what we're going to do. All I can do is test the living daylights out of you. You are going to be on enhanced supervision. Your order is from me. You will check in at the Reno Municipal Court today before 5 p.m. You may not get out until 1 or 2 o'clock in the afternoon. I don't care. You're going to be down to the Reno Municipal Court before 5 p.m. You will check in with the marshals. They will set you up with enhanced supervision. No alcohol, no drugs, no kratom. Do you understand?
Yes, yes, Your Honor.
You've been out long enough. There is absolutely no reason you should have any sort of hangover residue, any sort of hangover testing. I expect clean tests from here on out. If you test positive again, I will send the marshals out to have you arrested and we're going to talk again. Do you understand that?
I understand, Your Honor.
All right. Good luck, sir. I want you to do well. Good luck.
Okay, so.
All right. Thank you.
Okay.
Okay, we're gonna go on a really quick little field trip here, because I thought it was synthetic green. Apparently, it's not. So, tropical tree native to Southeast Asia. Its leaves produce stimulant effect and sedative. So but Kiki Blue said that you can get doot on it. Psychoactive ingredients. Oh yeah, we want people on that. Okay, so it can be Fang. Mostly abused by oral ingestion in the form of a tablet, capsule, or extract. Interesting. But they said you can buy it at a gas station, and that concerns me because you don't know what's actually in it, where it came from. It's not legally regulated. Not that I have a whole lot of love or trust for the FDA, but if there's no regulation on something, you could be consuming pesticide. You know?
That's okay. All right. Thanks, Judge O'Neill.
You're welcome, you Judge
All right.
Champagne. All right, I think we're ready to begin. Are the lawyers prepared to proceed?
Yes, Your Honor.
Yes, Judge.
Mr. Loomis, do you have a preliminary comment that you'd like to make, sir?
Yeah, yes, I do. We would stipulate to the fact that the names are correctly spelled, that there is a factual basis for any plea of no contest, and that we waive the formal reading of the complaints.
Thank you, sir. And I will just quickly address the audience. Good morning, ladies and gentlemen. My name is Shelley O'Neill. This is the time set for a video arraignment. An arraignment is your first appearance before a court. Well, what will happen this morning is I will call your name. You'll come up to the podium at the front of the room. The little black object in front of the podium or in the middle of it is a microphone. Stand as close as you can to that microphone so you can be heard. And so, because we are also being recorded. I'll read you your charge. I'll ask if you understand the charge, and then I'll take your plea. As you know, you have three choices. If you enter a plea of not guilty, you will be given a trial date. And if it's the type of offense for which you could receive jail time, I will appoint a lawyer to represent you. I will also order that you make contact with that lawyer prior to the trial date so the two of you can be prepared. No lawyer, no good lawyer can be prepared to proceed to trial and defend you if you haven't made contact with them. So if you don't contact them before the trial date, I can have you arrested for contempt of court. So please do that. Also, you'll be given the contact information, name and contact information of the lawyer. Please reach out. If you enter a plea of guilty or no contest, I'll go over your constitutional rights and possible penalties. I'll also ask you if you've served in the United States military, which I'm required by law to do. But I also want to advise you that if any of you are a veteran and you are charged with a more serious crime, such as domestic battery or DUI, that we do have a treatment court for veterans at the Reno Municipal Court called CAMO Reno. That stands for Courts Assisting Military Offenders. And you may want to speak with your lawyer, Mr. Loomis, or another lawyer if you're assigned one, if you're interested in that program. Also, if a fine is imposed or requested by the city attorney and you cannot afford a fine, please let me know. I cannot convert any fine, nearly any fine, to community service. It's my practice to give people at least 60 days to complete that community service, but you will have to, and if you're imposed, if a fine, community service, or any other obligation of the court is ordered, you have to report to the Reno Municipal Court immediately upon your release to set these things up. Don't think that you can just walk away, because if you don't do the things that you're ordered to do, you'll sadly end up back in jail because a warrant will have issued for your arrest. So please keep that in mind. If you have any questions, please make sure that you can contact Mr. Loomis or ask me. I'm happy to make sure that everybody understands exactly what's happening here this morning. I have a jail special attention list that I'm going to address first. And the first person on that list is Suzanne Alam Jasid, 24 CR 06486.
Good morning, Your Honor.
Good morning. Would you pronounce your last name for me?
Alan Gessed.
Thank you, Miss Alan Gessed. You were charged with, it looks like you have a charge here of a simple battery. Let me see, maybe 2 simple batteries.
A simple battery and a destruction of property.
I don't see the destruction of property charge.
Judge, the 2 batteries are back from 21, I think.
What? I wasn't hearing 21.
And it shows that it's closed. The one I have is 24 CR 06499, the destruction of property.
Well, let's see, that's interesting. I do not.
There's a new domestic battery charge that was filed on May 20th.
Yeah.
Okay, and I have that, May 20th, a domestic battery charge. And that's in 24-06-486. So, and I also have a note that Ms. Almgesed sent indicating she wanted to enter a plea. Were you advised of that, Mr. Loomis?
Yes, I was, and I've discussed that with her, and she does want to continue with the change of plea.
All right, on a domestic battery charge, or have there been negotiations to reduce that charge in any way?
There have not been as of this point, but I would defer to Mr. Altum as to whether he's prepared to do that.
Your Honor, we're prepared to take a plea if she wants to plead to the domestic battery. It's just a matter of if she did that, we'd have to try to notify the victim of imposition at a later date.
Right, and the other thing I would need is a domestic violence waiver of rights form. Has one been executed, Mr. Loomis?
I believe it has been executed with the assistance of Deputy O'Connell.
All right.
I have not yet signed it.
Let's see.
Did you receive the waiver? I believe I sent it back to you.
Yeah, let me check here real quick. I think I said I did. Yes. So let me see.
I only sent it to you just for the signature. I figured you would send it to the court.
Okay. Let me. I see that. Let me bring that up.
Yeah, I have reviewed this matter and I did not see a waiver of rights form, so I'll await that if it's being transmitted.
Okay, let me. What email address would that be to, Judge?
It would be to MASI, the letter M as in Mary, at reno.gov. That's my judicial assistant, Miss Messy.
Okay. I do have it. It has been executed along with the firearm ownership provision. Let me send that directly.
Thank you. And then let me ask you, Ms. Almsgezid, do you have the document in front of you that you have signed?
I don't have it in front of me.
All right, Deputy O'Connell is going to provide that to you while we're awaiting the copy of one for, because I'm going to be required to go over that with you, so I want to make sure you have it in front of you. It makes it a lot easier for you to follow. All right, while you're attempting to send that, Mr. Loomis, I'm going to go ahead and start the canvass.
Okay.
So, Ms. Almagessett, is your true and correct name listed on the document?
Yes, Your Honor.
All right, and on the left-hand border, it is the title of the document, domestic battery or domestic violence waiver of rights.
Yes, Your Honor.
All right, and on the left-hand border of the document, are there a series of initials which are yours?
Yes, Your Honor.
And did you place those initials on the document?
Yes, Your Honor.
All right, by placing your initials on the document, did you intend to tell me that you read it or it was read to you by your lawyer, Mr. Loomis?
Yes, Your Honor. I read it myself.
Did you have any question about its contents?
No, Your Honor.
Did you understand all of your constitutional rights that are listed in the document?
Yes, Your Honor, I did.
Did you have any question about your rights?
No, Your Honor.
All right, did you understand the maximum possible penalty for a first, second, and third offense domestic battery?
Yes, Your Honor, I do.
I want to be clear with you that a third offense domestic battery is a felony, and that is within a 7-year period. You could go to prison if you have 3 domestic battery convictions within 3 years or 7 years. Do you understand?
I do understand. Yes, Your Honor. I don't
All right.
anticipate having a problem.
Well, thank you. I hope that that's the case. We all hope that that's the case. All right. What is your date of birth?
November 24th, 1980.
And is that correctly stated on the document?
Yes, I do believe. Yes.
On the last page, then? All right. And have you served in the United States military?
No, I am a spouse, so my husband
All
is.
right. And what is your plea to the charge of domestic battery?
No contest, Your Honor.
Do you understand by entering a plea of no contest that the court, which is me, will find you guilty of the domestic battery?
Yes, Your Honor.
All right. The court will accept your plea as freely, voluntarily, and knowingly entered with the proviso that both the lawyer and the court will be required to sign that document. I'll go on. There should be another document for you as well. Do you see that? It's called a declaration relative to firearms.
Yes, Your Honor.
All right. And is your name correctly stated on that document?
Yes, Your Honor.
All right, and do you understand now that I've accepted your plea to domestic violence charge that you are no longer allowed by law to own, possess, or control a firearm?
Yes, Your Honor.
And do you understand the consequences of that, of violating that provision?
Yes, Your Honor.
It's a felony and you could go to prison for that.
Okay.
All right,
Yes,
you
I do understand, Your Honor.
All right. And then is the city attorney requesting time to present a victim impact statement, Mr. Altum?
Yes, we would request time just to try to contact the victim regarding sentencing.
How much time would you need, Mr. Altum?
Today's Thursday, the 30th. We could put this on Monday.
All right. Any objection to that request, Mr. Loomis?
No objection.
All right. And Ms. Olmsted, I will tell you that the state law requires that I give the city attorney a reasonable amount of time to contact a victim in this type of offense. So So we're going to continue this matter. There will be a no bail hold on you until Monday to allow the victim to be present to basically present whatever side of the story they want to do. We will proceed no matter what. If the victim doesn't show up, we'll still go ahead with your sentencing, okay?
Okay, and I'm not gonna get sentenced today?
No, you can't get sentenced today because the city has requested time to contact the victim.
Oh, okay, okay.
Okay, so you will be sentenced on Monday, okay?
Thank you, Your Honor.
All right, thank you for your cooperation. I appreciate it.
Judge, and she's also here on a sentencing for destruction of property.
Why don't we continue both of those? Does anyone have any objection to that?
No,
We'll
Your Honor.
continue that until Monday as well. Thank you, Ms.
No
Gonzalez.
objections.
Thanks,
Thank
Judge.
you.
Marcy's Law. That's the contacting the victim thing.
The next matter I have before me on the special attention list is Jack Hammond.
Good morning, Your Honor.
Good morning, Mr. Hammond. I have two matters for you this morning. They're both, one's listed as a revocation hearing, and that's case 24 CR 05879. And so that is for a petty larceny that occurred on May the 6th, 2024, obstructing and resisting a police, the petty larceny was dismissed and you were found guilty of obstructing and resisting a police officer by non-compliance. Looks like you were found guilty of that offense, and it looks like you may have been on a suspended sentence for one of the other courts. And let me go to that one next, and that's case 24, that's case 24 CR 06634. And that's a sentencing hearing. And it looks like you've entered a plea of guilty to placing another assault and simple battery charge, and you entered those pleas on May 23rd, 2024. The other charges of trespassing, disturbing the peace, and obstructing and resisting a police officer were dismissed pursuant to negotiations. Are we prepared to proceed to sentencing here today, sir?
Yes, Your Honor.
All right, and Mr. Altum, are you prepared to proceed?
Yes, Your Honor. We did look into attempting to call back or locate or identify any victims. The Indian Colony police officers did not identify the names of the victims, but we did reach out to one security officer that we did have that was not necessarily involved, but we haven't heard back anything.
All right. And so do you want to go ahead and proceed then? Are you
Yes.
prepared to proceed to sentencing, Mr. Loomis?
I am.
Very good. I'll hear the city's recommendation then.
Your Honor, on the battery case, assault and battery, the city's going to be asking for a total of 45 days jail up front. He has a terrible criminal history. He has that other suspended sentence. Here he attacked some security officers there at Walmart. And then I would ask for revocation in the other case. I'd ask that 45 days be consecutive to his suspended sentence. When somebody's on a suspended sentence for obstructing and resisting, they commit a new crime like this, does not appear that they'd be a good candidate for probation. Thank you.
And Mr. Loomis, I'd like to hear from you, sir.
Thank you, Judge. Mr. Hammond is 23 years of age. He has lived in Reno for 2 years. He's got what I would consider kind of a minor criminal history in Reno. I don't have any criminal history from elsewhere. He is homeless. He's not working. I did suggest that the community court might be something that would be valuable to him, but he is not interested in doing that. He wants to serve his time and be done. So I would ask, I think the revocation of the 10-day suspended sentence in 05879 is inevitable. I would like the court to consider something less than the 45 days and maybe perhaps 20 days on the battery and the assault.
All right. And Mr. Hammond, I'd like to hear from you. What What caused you to do this type of violent offense to Walmart security officers? It's just, it's not right. They're just doing their job. What caused you to be here today facing these types of charges?
I stole some wine and I got hungry and I went back to go steal some food. And we just got into it and we just butted heads until I acted out and got arrested.
And you know that you don't have to steal food in Reno. There are a number of places that you can go to get food for free.
Oh yeah, now I remember. I'll always keep that in mind, Your Honor.
All right. Well, I'm not happy with the fact that you used violence against somebody who was on the job. They don't have a choice. They can't turn around and walk away. They can't run away because they're trying to do their job. And when you inflict or when you scare people with threats of harm, or you hurt them or attack them in any way, that you're breaking the law. Do you understand?
I do.
All right, sir. Based upon that, I will revoke the 10-day sentence. And give you credit for time served on that sentence. I'm going to sentence you to 90 days, 30 days on the assault, and 60 days on the battery. I'm going to order that you serve the 30 days consecutive to the 10 days up front and have the balance of the 60 days hanging over your head for a year on the following conditions: that you obey all laws, you have no alcohol or drugs without a valid prescription, including marijuana, and I'm going to order that you go to the community court and check in when you're released from custody, because I want you to be provided services. They can tell you where you can get clothing and food and Medicaid insurance and food stamps and all the things that you're going to need if you are homeless. Do you understand?
Yes.
All right. And the community court is located at the Washoe County Library, which is located on the corner of Center and Liberty Streets in downtown Reno. So when you're released from custody, you first need to go to the Reno Municipal Court and check in with our Marshals Division, because you will be supervised. And then you need to go, and they'll tell you it's every Wednesday morning at 8:30. So if you're released, and you're not on Wednesday, you're going to need to go over there on any given Wednesday as soon as you get out and report into the community court. Okay?
I don't want to do that, Your Honor.
You don't want to do it?
No.
All right, then I'm not gonna order it, because it's something that could be helpful to you. But you understand that if you get caught breaking the law again, or under the influence of alcohol or drugs, I'll put you in jail for the balance of the sentence. Do you understand?
I do, Your Honor.
All right, that'll be my order.
Your Honor, could we have a no contact clause as well at that Walmart, please?
Yes, there'll be a no contact with, is it the Walmart on 2nd Street?
It's 2425 East 2nd Street in Reno, correct?
Yes. All right, you need to stay out of that Walmart, because you've been trespassed from there. If you go back in, you're going to be arrested and you will have broken the law, and you'll have to then serve the balance of your sentence. Do you understand?
I understand. No going to Walmart. I understand. I had a 30 and a 60. Do you know how
Yes.
much time I got to serve before I can get out?
Sure, the jail will do that calculation for you based upon the amount of time you've already been in, okay?
Okay.
All right. Any other questions?
No, thank you, Your Honor.
All right, good luck.
I really did appreciate how she tried to mom him. And she's like, you didn't have to steal the food, because there's a number of places you can get food for free. I am not happy about this. I wouldn't want to be in front of a judge that did that. I would feel like I disappointed them, It's that total mom vibe or dad vibe when they do that, and I think that's what they're going for, because unfortunately a lot of these people came from broken homes and didn't have both parents, and that has a lasting effect on how they turn out. And when you're in front of a judge that disciplines you like that, it's embarrassing.
I apologize. It was 30 on the assault, 60 on the simple?
Yes.
And did you say for how long? I missed it.
Yes, for 1 year.
1 year with 30 up front?
Yes, and then he also was revoked on the other matter for 10 days.
Thank you, Your Honor.
All right, the last matter I have on the jail special attention list is Wilbur Oriel Noguera.
Judge, I spoke with Mr. Noguera, and he seems to be unaware of where he is and what he's doing, and was making no sense. He's been taken back. I think a competency evaluation may be warranted here.
All right, I'll go ahead based upon the representation of counsel. I will order a competency evaluation. There'll be a no bail hold on Mr. Oriel Noguera until that competency evaluation has been completed. All right. And then I'm going to start at the top of the lineup after we've addressed the A's. And the next matter I have is Mac Ballard, 24 CR 06737. This is a sentencing hearing. Good morning, Mr. Ballard.
Good morning, Your Honor.
Mr. Ballard, you entered a plea of no contest on May 25th, 2024 to the charge of simple battery. And we continued the matter out to allow the city attorney to make contact with the victim in this matter. Is the city prepared to proceed?
Yes, Your Honor.
And are you prepared to proceed, Mr. Loomis?
Yes, Your Honor.
All right, go ahead, Mr. Alton.
Your Honor, we did attempt to reach out to Scott Nelson, the victim. The defendant punched a complete stranger on the street, knocked out his tooth. The victim has not responded to our phone call. The defendant does have a terrible criminal history, including history of violence, felony, violation of felony conditions of release, etc. And I can get more into his criminal history specifically if you would like, based on my recommendation, which is going to be 120 days in jail up front. With his criminal history, does not appear to be a good candidate for any kind of probation. This was just a violent crime on a stranger walking down the street.
Why would he do that?
Well, and I also mentioned to Mr. Ballard, Mr. Altum, if you weren't here, that I would suggest that there's a possibility that a broken tooth could be substantial bodily harm, and that the city attorney's office could have sent this over to the district attorney's office for prosecution as a gross misdemeanor or felony. So now that he's entered a plea to a misdemeanor, I believe that he's gotten off very lucky. Mr. Loomis, what would you like to say relative to Mr. Ballard and sentencing?
Well, what he reports is that he came up here from Sacramento to try to find work at Tesla and has been here in Reno for 4 years. He did not get that job, but is presently looking for work and is also trying to take advantage of certain Social Security disability benefits as a result of a bad foot. He has a son in Sacramento. As you read the report, the reason for the battery is reported to be the fact that the person they attacked and his girlfriend were saying bad things about him, but nobody says that actually happened. But that's the impression he was under.
Okay, thank you. Mr. Ballard, is there anything you'd like to tell me before I impose sentence?
All I have to say is I'm just trying to do right. I've been like busting my tail off just trying to get my birth certificate so I can go back to work. I was working at Staff Mark here. Things have not been really great, even from me getting out. Prior to me getting out last week, when I went to the CARES campus, now there's like no overflow or nothing. So I hadn't been asleep for days. But I've been trying to do right. I wasn't trying to be a nuisance. I wasn't trying to be like a severe problem to anybody or anything. You know, the situation just happened. I just was trying to defend myself, not to get too deep into what happened, but I'm not a terrible person or none of that. I have had employment since I've been out here in the past. I'm just trying to get back to work. That's it.
All right.
Let's get back home.
Thank you. Well, Mr. Ballard, when you say you're trying to do right, but you hurt someone. Yeah, and I understand you say that you're trying to defend yourself, but the police report and the witnesses indicate that it was some stranger that you just lashed out and harmed. And I understand how frustrating it is to be homeless and not have a safe place to sleep. But that you shouldn't take out your aggression and your frustration, your lack of sleep or lack of a safe place to sleep on strangers. I think you hurt someone. And like I said earlier, when we took your plea, that you are very lucky that you're not looking at prison time based upon the broken tooth. When you hurt someone and it's permanent injury, you could go to prison for that kind of stuff. So based upon your criminal history, the lack that this was an unprovoked assault, you inflicted violence upon someone, I'm going to sentence you to the full 180 days in the Washoe County Jail. You will be given credit for all time actually served. Okay?
Yes, ma'am. Yes, Your Honor.
And you may want to check with the jail. Since you're going to be there a while with their inmate assistance program, they may be able to find your birth certificate for you, okay?
Inmate assistant?
Yeah, they have a program that can help you with the ID, okay?
Yes, ma'am. Thank you.
Good luck.
Housing
Good luck.
and food and
Your
everything
Honor?
else.
Yes.
I do have a few inmates that will need to go to Reno Justice Court after this, if we could take them next.
Yes.
Hi, Cutie
First one will
Marshall.
be Bermudez Magana.
Don't want to stay. This is too much for you. You can leave. Then stop making comments.
So let me see if I can find that person. All right. Alvarado Bermudez Megana, 24 CR 06875. Good morning, sir.
Good morning.
Let me pull up your matter. Mr. Bermudez said, Magana, you were charged with the crime of obstructing and resisting a police officer by non-compliance and obstructing or damaging road or street or an alley. And that is on May 29th. That's when the allegation occurred. Did you understand the charges?
Yes.
That applies to so many.
And how do you wish to plead? Are there any offers to be tendered here, Mr. Altum?
Your Honor, if he were to plead to anything, this is kind of a unique case that, in my experience, he threw a railroad tie, according to reports. I wasn't there, obviously, but railroad tie into the road and caused an accident. So we would need to reach out to the victim of count 2, obstructing the road or street, were he to plead to either one, just for purposes of possible restitution. But if he did plead to the obstructing with an agreement to pay restitution on count 2, we'd be willing to dismiss count 2.
All right. And did you understand that offer, Mr. Alvarado Bermudez Magana?
I'm not entirely sure.
Sure. Well, and I'm happy to go over it, or your lawyer can. The city attorney has offered that if you want to enter a plea to the obstructing and resisting a police officer by non-compliance, he'll dismiss the other charge, but you have to agree to be responsible to pay for any damage you may have caused by throwing the railroad tie into the road where a car ultimately ran over it and crashed or was damaged in some way. Do you understand?
Yes.
Do you want to accept the offer?
I need to.
You want to discuss it with me,
Yeah,
Mr. Magana?
All right,
we go private?
We'll go into a waiting room, Mr. Bermudez Magana, and you can talk to Mr. Loomis, your lawyer, okay?
Okay, thank you very much.
You're welcome.
Placing you and Mr. Altum into the waiting room.
Thank you.
So, Mr. Magana, what they're asking for is, since you threw the railroad tie into the street and it caused an accident which did front end damage to the vehicle that the other person was driving, and he suffered a minor injury, they want you to pay him back for the damages that he has suffered. They're not going to do so. If he had to go to the hospital to get treated, the hospital cost would be on you, but I don't think that happened. It does describe front end damage to the car, which can be expensive, but they want you to pay for it as restitution.
is there like a payment plan or something like that, or?
You can ask for a payment plan, yes.
And really, I just don't want to be here because I want to get back to work, get going, and
Yeah.
uh,
Well,
I don't-
I think, you can ask for a payment plan. I will ask for it on your behalf. And they're fairly reasonable, like along $100 a month. Is that something you can handle?
yes, that's
Yes?
awesome.
Okay. Well, they're gonna have to find out how much it is first, but they will accept payment plans.
That's
Okay?
no problem. I just, I don't want to hurt anybody, and I thank God that they didn't get hurt like that bad, or if it's minor,
Right.
whatever it is.
Okay.
So don't throw railroad ties in the road.
Okay, so I think we're ready to proceed, Michelle.
Thank you.
Just give me a moment.
Serious audacity of these people. I don't want to hurt anybody. I'm really a great guy. I just want to go back to work. I just want to help my family. All the excuses. The last guy did it too. Do something absolutely foolish, hurt someone, and then act like you're being victimized because you have to go to court or be in jail. Such entitlement.
All right, thank you for your patience. I had to answer an email this morning. So, Mr. Bermudez Magana, have you had ample time to speak with your lawyer, Mr. Loomis?
Yes, ma'am.
And what is your decision relative to the offer that's been tendered to you?
Judge, what he would accept the offer. What he would like to do is, in terms of the restitution, establish a payment plan that he can afford to make the restitution payments. He does have a job. He's held a job for a while, so it looks like he can afford $100 a month.
All right, well, I'm not going to negotiate that, but I always allow people to set up a payment plan, Mr. Loomis, so he can set that up with our court clerk if he wants to go ahead and proceed and take the deal, okay?
Okay.
Mr. Bermudez Magana, do you want to go ahead then and accept the negotiations?
Yes.
And what is your plea to the charge of obstructing and resisting a police officer? Your options are, if you want to,
No contest.
right.
Yeah.
and if do you understand by entering a plea of no contest that the court will find you guilty of the obstructing and resisting charge?
Yes.
Yes. Did you understand your constitutional rights?
Yes.
Do you have any question about those rights?
No.
You understand that the maximum penalty could be up to 6 months in jail and or a $1,000 fine.
Yes, I understand, but
Okay. That's a possibility. I don't know that I'm going to give that to you, but you need to know what the maximum possible penalty is whenever you enter a plea. Wouldn't you agree?
yes.
But and have you served in the United States military, sir?
No.
The court will accept your plea as freely, voluntarily, and knowingly entered. We're going to continue this matter over. Are you looking for Monday as a possible date for sentencing, Mr. Altum, based upon your request to contact the victim?
Yes, please, Your Honor.
All right. So, Mr. Bermudez Magana, you have another matter, I guess, in Reno Justice Court. Does the city have any ideas or suggestions relative to bail in this matter?
Your Honor, we just asked to keep him in custody until Monday for imposition.
All right, there'll be a no bail hold placed on Mr. Bermudez Magana till Monday for sentencing.
Is there any chance, Your Honor, that I can get out because my work is actually Saturday and Sunday. I work part-time for Chewy, and I don't want to lose that job. I will make it to court. I just don't want to lose the job, please.
All right, I because obviously restitution is going to be considered here. I'm going to go ahead and set an out of custody arraignment, release you on your own recognizance. And we'll go ahead and give you a date, Mr. Altum, that you can have the victim available. Do you have any objection to that, sir?
Your Honor, there is a risk once somebody enters a plea that they don't come back. We'll see that quite often, but you make a good point regarding restitution. Excuse me, it'd also give us time to probably send out a letter to the victim as well, which can sometimes be more effective than just trying to phone them.
Thank you. And Mr. Altum, I also recognize that he still has another court appearance to make this morning, so there may be some bail set there. So Mr. Bermudez Magana, I'm going to go ahead and OR you here on this charge, and we're going to give you a sentencing date. We'll give that date to you now, and so you need to come to the Reno Municipal Court for sentencing on the obstruction and resisting. May I have that date, please?
Yes, Judge, that's June 20th at 8 a.m.
All right, sir, I expect to see you on June the 20th at 8 a.m. in my court. And you'll be prepared. We'll sentence you on that date. Okay?
Sounds very good.
Thank you. Please don't let me down.
All right, go through that blue door, through the hallway, through the next blue door. Grab us in the back row. Your Honor, the next one, if we could, is Quinn Crowcroft.
Okay. I got it. That's 24 CR 03106. Mr. Crowcroft.
Morning, Your Honor.
Good morning, sir. You have two allegations here this morning. The first one is violation of your release conditions prohibiting contact from March the 10th and a failure to appear warrant on March the 30th. Did you understand why you were arrested, sir?
Yes, ma'am.
She's kind of letting the other charge that he's in on be the deciding factor on him getting out. So she PR'd him on the charge that he's in front of with her, knowing that he has court later on for another charge. And he's, gonna be going up to figure out bond on that one too. So the second charge will be the deciding factor on whether he gets out or stays in.
All right, and let me go and see here. I'm opening up the warrant now.
If I'm wrong on that, let me know. But that's how I interpreted it.
All right, there was an arrest warrant issued on May the 1st, 2024, pardon me, by Judge Jean Draculich. And that warrant indicates that you had a failure to appear on April the 30th, 2024 for violation, obviously for prohibiting a no contact order. Bail was set in the amount of $1,000. Do you understand the charge, sir?
I do, ma'am.
I like it.
All right. And do you admit that you are in contempt of court for failing to appear for that court appearance on April the 3rd? Do you wish to be heard, Mr. Loomis?
Yes, please, Judge. I discussed this case with Mr. Cocroft, and what he indicates is he understands that he came into court, talked to the court clerk's office, and they explained that the case had been closed. Now, we did, hypothetically, if it hadn't been closed, Mr. Cocroft is prepared to address the issue, but initially he says that there was discussion with the court clerk that said it had been closed.
Okay. So, and I don't have the original no contact order, so let me see if I can. And when that occurred, it looks like on March 11th, a formal complaint was filed with the court. I'll look at that. All right, the indication is that, and this is a criminal complaint that was filed on March the 11th, 2024 by Officer Becker. And it is a violation of release condition prohibiting contact on 5th and University Way. You were issued a stay away order through the Reno Township Justice Court that was served on December the 5th, 2023 and expires on April the 6th, 2024. And you violated that order. You were issued a verbal, as you were involved in a verbal verbal altercation with the appellant Shalene Payne. I think that he meant the applicant. So I don't know that we have enough information here relative to that stay away order, since that's out of the Reno Justice Court. What's your position on this? You've indicated that you think the case is closed, and I don't have any information to that. Shall we continue this matter over to see if we can get information from the Reno Justice Court? Because obviously, if he spoke with the clerk at the Reno Justice Court, we wouldn't have that information in our system.
Your Honor, I'd note that the court system shows that he entered a no contest plea on March 12th to the single charge of violating a condition prohibiting contact.
Okay. And then was there sentencing in that matter, or was the failure to appear these?
There was a sentencing set for April 30th, and he failed to appear for that sentencing hearing.
Okay. All right. Well,
no contest.
Okay. So you have already entered a plea of no contest, Mr. Cocroft, to violating that condition. And it looks like you were continued over for sentencing and then failed to appear for sentencing. So let's start backwards. Did you appear for court on the day you were ordered to appear?
Yes, I did. And when I appeared, when I went, I talked to the court of clerks and I said that I have a court, I have a hearing today. I have to go out of court. They said that the case was closed. That's what the court of clerks told me. So
all right. So which court clerk, the Reno Municipal Court or the Reno Justice Court, did you talk to?
Right. And I understand that I had a no contact order in both courts. So I asked for both courts. They said that the case was dismissed, and I was turned around. And so I walked into the court and asked them where do I need to go. The court of clerks said that the case was dismissed. So then I left. And this was right after because I had been released, and I went on my own. I went on my own recognizance that day, and I just went, and they told me that not to. That the whole case was dismissed because she actually went in and removed that contact order. She didn't want. You know what I mean? That's what I was told.
It expired on April the 6th.
Yeah.
But the allegation that you entered a plea of no contest to was that you violated that stay away order on on April the 30th. You were supposed to be sentenced.
All right. Well, it said that it was I don't know. I went in and did a couple of days on that and did this and did that, and it said that it was that the contact order was what did you say? It was
it basically expired. Sure.
It's expired. So I don't even know what I'm still doing right here.
So when were you arrested? 29th. When were you arrested, sir, on this outstanding warrant?
29th.
On the 29th?
Yes.
Okay. And so I'll hear from the city as to sentencing.
Yes, ma'am.
Your Honor, our difficulty here is that the entry of no contest plea was on March 12th and in front of Pro Tem Judge Steve Silva. It was set for sentencing, likely for victim contact, on April 30th in front of the same judge, Judge Silva, at 1 p.m. He failed to appear for that. And so our difficulty here is victim notification of today, essentially another imposition or sentencing date. So we need to reach out to her again and be able to let her know her rights as a victim.
All right, and I agree. And do you have any objection to that, Mr. Loomis, if I continue the matter for victim contact till Monday?
No.
All right, so I'm gonna go ahead and, Mr. Cocroft, I am gonna continue. The city attorney has made a request. And by state law, I have to honor that request to allow him to make contact with the victim in this matter, to ensure that she has the right to testify if she chooses. If not, we'll go ahead with sentencing on that date. It'll also give us the time to clarify if there are any notes in the file that you made contact with one of the Reno Municipal Court clerks relative to your failure to appear, okay?
Good luck.
So there'll be a no bail hold pending sentencing on Monday,
No bail, so I have no bail on this, so I have to wait till Monday.
until Monday.
All right.
All right, and I'm gonna step aside for just a second. My phone is on low battery. I'm gonna grab the charger. I'll be right back. All right, and our next matter then,
Your Honor, it'll be Chad Stewart.
okay, thank you. Mr. Stewart, if you'd like to come forward.
Yeah.
It's 22 TR 16274. Good morning, Mr. Stewart.
Morning, Judge O'Neill.
Mr. Stewart, you are, let's see, let me open it up. Looks like a traffic matter. You have two cases displaying bogus vehicle registration plate or title on December the 16th, 2022. So this is an old case.
Say he was traveling.
And then an alleged failure to appear from January the 17th, 2023. Did you appear for court, sir, on January the 17th, 2023 for that no registration charge?
No, I didn't, Your Honor.
All right, so are you admitting that you failed to appear, sir?
I did fail to appear, yes.
And you understand that failing to appear is contempt of court, for which you could receive up to 25 days in jail and a fine up to $500?
Yes, Judge.
All right, did you understand your constitutional rights, sir?
Yes.
Do you have any questions about those rights?
No,
You're giving up your right to have a hearing by entering an admission
right.
relative to the failure to appear. I haven't taken your plea yet on the registration. We're just talking about the failure to appear right now. Do you understand that?
Yes.
All right, and are you a veteran or have you served in the military?
Yes, U.S. Army.
All right, well, it's your lucky day, Mr. Stewart. I am the Veterans Treatment Court judge, and veterans, teachers, and first responders always get a break in my court. So I will go ahead and accept your admission as freely, voluntarily, and knowingly entered. What is your plea to not having valid registration on the date of December the 16th, 2022?
Right. I came all the way from Jersey. I was kind of recruited by Tesla to come work at the Gigafactory. It takes about 6-7 months of application and a lot of background checks. They actually start working there. So I had my New Jersey plates on for longer than it's supposed to be. And when I was stopped by the officer, he thought I was driving too slow, and thought maybe I was impaired or something. I said, no, everything's fine. I gave him my paperwork. He said, how long have you been in Reno? And I said, I told him the truth, about 6 months at that point. And he said, well, you're way past the time that you're supposed to change everything over. And that's primarily the reason why I was cited, because I took a test and
Well,
everything.
couple of things, Mr. Stewart, and that's only required if you permanently change your residence. If you're
Right.
temporarily working here and there are people who are on assignment and your permanent residence is New Jersey, then the officer may be incorrect. So is your permanent residence New Jersey or Nevada?
At that point, it was still New Jersey, but right now it's Nevada. I've been here ever
Okay.
since. Yeah.
And have you registered your car?
Well, actually, a month and a half after that incident, the car's problems with the transmission. It's a 2011 Hyundai. I didn't have the money. I just started working at that point at Tesla. I didn't want to put money into the car, and Tesla has a shuttle service back and forth. So I actually don't even have the car anymore. The car's been scrapped. basically.
Okay, so here's what I'm gonna do. When were you arrested on the outstanding warrant, Mr. Stewart?
Yesterday.
All right, I'm gonna sentence you to time served on both matters. I'm gonna go ahead, I'm gonna dismiss the registration charge based upon our discussion in the interest of justice. And I'll sentence you to time served on the failure to appear. If you do get another vehicle, I know that as a veteran of the military, that you're a rule follower and that you will properly register any vehicle that you drive in Nevada, correct?
Absolutely. Mhm.
All right, you should be released today, sir.
Okay. Thank you.
I like him. And I'm really glad that that's how that one shook out. Yeah, I really do like him.
You're welcome.
And Your Honor,
Yes.
I do have one interpreter matter as well.
Oh my gosh. Okay, I'm sorry to have kept the interpreter waiting. What
doesn't.
number, what matter is it?
It's Hurtado Calvillo.
Okay.
Good morning, Your Honor.
Good morning, Mr. Guzman. 24 CR 02426.
Safe.
Good morning, Mr. Gerardo Cavillo.
Good morning, Your Honor.
Just, and this is a sentencing hearing pursuant to, it looks like Mr. Hurtado Cavilla entered a plea of guilty on February 27th, 2024 to the charge of domestic violence, TPO violation. And then he looks like he also had an arrest for failure to comply with the court's order. He admitted to that. So this is the time set for sentencing. Is the city prepared to proceed on sentencing for Mr. Hurtado Cavillo?
Your Honor, I apologize. It sounds like the victim was noticed for a June 10th, 1 p.m. date. Looks like Miss Janoli from our office was on this case in videos just a couple days ago, and everything was, according to her understanding, is still set for June 10th, and we're just waiting on an evaluation. So from our office's standpoint, it sounded like the imposition was still just set for June 10th while we were waiting for the eval. So we have not been able to notice the victim for today's hearing.
And so what is your proposition to continue the matter till June 10th?
We could either try to reach out to her by Monday and do this Monday, or keep it on calendar for June 10th. Monday might be easier.
And I don't see, have we received an evaluation, my court staff, please?
You.
Your Honor, I received a eval this morning at 9:11 a.m. Looks like it recommends it would kind of be like, if it were a DUI type case, it would be like a level 3.
Probably waiting
All
a
right.
eval.
So I think that I was just concerned that there might be a time delay if the evaluation had not occurred. So I will go ahead and, unless you have any objection, Mr. Loomis, I'll issue a no bail hold on your client until Monday, where we can go proceed to sentencing, give the city the opportunity to contact the victim. Then he wouldn't have to wait in jail until the 10th, where they had previously noticed the victim. Do you have any objection to that procedure?
No
Mr.
objection,
Loomis?
Judge, and I do have a copy of the evaluation, and Mr. Marcelo has it also, and he's gone over with Mr. Haraberti.
Very good. So, Mr. Guzman, if you would confirm that you have gone over the evaluation with Mr. Hurtado Cavillo and let him know that we're going to continue the matter till Monday morning, and there will be a no bail hold on him until that date.
I did explain to him, Your Honor, and I went through the eval with Mr. Hurtado. He understands that he knows the results of the eval. And
Very
he-
good. All right. Well, that'll be my order then. He'll be continued till Monday. Thank you, Mr. Guzman.
Thank you, Your Honor. Salud con la mañana.
Oh. Any other matters of urgency, Deputy O'Connell?
No, Your Honor, thank you.
All right, no problem. All right, we are I think our next matter is, let's see, Michael Bearden, 23 TR 13515. And there's another matter, a sentencing matter, 24 CR 06743. Good morning, Mr. Bearden.
Good morning.
Mr. Bearden, the first matter I have is contempt hearing, and that's in 23 TR 13515. And sir,
Judge,
it looks, yes.
my understanding of this was, he was here for a bail hearing. Let me just confirm that.
All right.
No, that's sorry, that is somebody else.
Okay. It looks like Mr. Bearden entered pleas or was found guilty on October 25th, 2023 for registration required invalid plates and no insurance. And then there was an arrest in February for failure to comply with court order that he denied. And so the matter may have been set for hearing. Typically, Mr. Bearden, what all the judges in municipal court do relative to these type of offenses, your registration and insurance, is give you the opportunity to cure, which means get registration and insurance. Did you ever do that?
So not on that vehicle, but I had bought another vehicle after that, and I did have that insured, not completely registered. Money was the issue on that. It was a bit expensive. I was just trying to save the money to do so. But with this DUI, I don't think I'll have that vehicle anymore.
Okay. All right. Well, can you provide the proof of insurance? And I would consider giving you time served on the registration.
Yes.
Depending what's going on. Okay. And was your car insured on the date in question, the day you got your citation, or did you go out and get insurance after the fact?
After the fact.
All right. So you need to enter a plea of guilty or no contest to not having insurance on the date in question. And it looks like you have been. So what I typically can do is reduce the fine down from $743 down to $195. Do either of the attorneys have any objection to sentencing Mr. Bearden on those two charges to time served?
No, Your Honor.
No.
All right, so we'll close that matter up. And I'm going to go ahead and dismiss the failure to comply with the court's order contempt charge based upon what I've heard here today. So let me go to the other matter. Is sentencing hearing on 24 CR 06743. And it looks like you entered a plea of no contest to DUI, alcohol and or drugs first offense, and minor in possession of an alcoholic beverage in public on May the 26th. Are both parties prepared to proceed? It looks like the matter may have been, because he is a minor, an evaluation was required. Do we have an evaluation in this matter?
I don't believe we do, Judge.
Your Honor, this case
yesterday.
was. Oh, I
Ms.
apologize,
Massey?
counsel. I apologize, counsel. This matter was heard yesterday. He entered a plea, but there was not a DUI waiver completed, so he was continued to today for a waiver and imposition. I'm not sure that happened again.
All right. So, Mr. Loomis, do you have a waiver in your file that you can share with the court, or do you need some time to go over a waiver with Mr. Bearden?
I am going to need some time to go over the waiver with Mr. Bearden, but he is 20 years old, so he will need an evaluation.
All right. So what I'm going to do then is I'm going to continue the matter. Mr. Bearden, are you working now?
Yes, I am. I'm working at High Mountain Door and Trim. I'm a manager in the company as of now. Hopefully when I go back, I still have that position. I'm working there full time. I've been there for almost 2 years now, come September.
All right. Based upon the fact that he's entered a plea of no contest to the minor in possession and DUI alcohol, I'm inclined to release him with supervision and a no alcohol clause and have him get his evaluation and set a sentencing date out. It sounds like he's been employed for a protracted period of time. And as a young person, I find that commendable. This is a DUI first. Do either of the lawyers have any objection to that process?
No, Your Honor, I would just ask that he be on enhanced testing pending that. Sounds like, give me 1 second. It sounds like it was alcohol as well as dabbing with cannabis. So some enhanced testing for both alcohol and drugs would be our main request, and no driving unless legal to do so.
All right. Anything you'd like to put on the record, Mr. Loomis?
Judge, I have not seen, he took a blood test and I have not seen the result of that blood test at this point. So
Okay.
other than that, I have no other comments.
We don't
All
have
right.
one.
Mr. Bearden, and what I'm going to do is release you on your own recognizance, and that's a legal term for basically I'm going to trust you to come to court.
I appreciate it.
There are going to be several conditions on you though, and they are as follows: that you obey all laws. That means no alcohol, of course, because you're under 21. But there is also an attendant no alcohol or drugs clause. So you'll have no alcohol or drugs, including marijuana, during the pendency of this case, and probably for a long time thereafter. I also will order that you be placed on enhanced supervision with testing, in order that you have what we call an OSM, which is an handheld alcohol monitoring device, on your person within 24 hours of release. So I know that you're not going to be drinking and driving. I want you to stay alive until I see you again. As the city attorney has requested, no driving unless you're legally able to do so. So if you had to surrender your driver's license to the police officer, you're not allowed to drive. And if you get caught driving after you've surrendered your license, or your privileges have been revoked due to the alcohol charge by DMV, I must put you in jail for a minimum of 30 days up to 6 months and fine you $500 to $1,000. So please don't drive if you're not legally able to do so. Do you understand?
I do.
All right.
I'm not too sure if I am. During the booking or whatever, I forgot her name. She did say that my license will not be suspended. I think because I did the
It's
blood
because
test
you
or whatever.
probably did a blood test and we don't have the results to confirm that you were under the influence.
Okay.
So, but I will tell you this is how it works. When the blood test results come back, then they'll go to DMV, and if you're over the legal limit, DMV will send you a certified letter to the address on your driver's license. So if you've moved since then, you probably need to be proactive about notifying DMV where you live. So you'll get a certified letter telling you that your license maybe has been revoked for, depending on if you cooperated with the police officer and you took a test, or you were forced to take a test by a search warrant, then you aren't legally able to drive for a year. So you're going to have to talk to your lawyer about that. I'm going to release you today. I will order that you report immediately upon your release to the Reno Municipal Court. That's before 5:30 today, to set up your testing. Do you understand?
I do.
All right, you should be released, and then we're going to give you a sentencing date now.
Your Honor, I have a question as well. The sentencing would be July 17th at 8 a.m. Do we want an in-house evaluation or an out-of-house evaluation?
Mr. Loomis?
I'm happy with an in-house evaluation.
All right, so Mr. Bearden, and we'll go ahead. Thank you, Mr. Loomis. I'm sorry to cut you off. Mr. Loomis or Mr. Bearden, when you check in with the Reno Municipal Court, they're going to give you or you want to give an evaluation date now, Miss Massey?
Yes, Your Honor.
Thank you.
We can do Monday, June 3rd at 1 p.m., 2:30 p.m., or 3:45 p.m.
Mr. Bearden?
Monday. That's this coming Monday, right?
Yes.
What are the times on that again?
1 p.m., 2:30 p.m., or 3:45 p.m.
Can we do 3:45, please? And that'll be, where will that be at?
At the Reno Municipal Court.
Okay.
And they'll direct you, because you're going to go over there today, and they'll tell you where then the evaluation will happen, and they'll give you the documentation you need relative to testing, okay?
All right. And then as for my OSM device, will I get paperwork for that today?
Yes. Yes, they'll tell you how to do that as well.
All right. I appreciate it. Is that it?
Yes, that's it. Remember that your sentencing date is July the 17th at 8 a.m.
All right.
Please be there, okay?
Thank you.
And, Your Honor, I did
Yes,
have
Mr.
one other
Loomis?
question.
Sorry.
Mr. Bearden,
Mr.
Judge, how do you
Bearden, come
wanna-
on back.
how do you want to handle the waiver form?
I'm not sure I can.
Well, I'm asking the judge.
That's a good question. Do you want to set a time to meet with him, Mr. Loomis? When will you next
Monday,
be at the
please be
meeting?
there Monday at 3:45.
Yep.
Okay, let me just check that.
We need that waiver form, Mr. Bearden, to go make it a constitutionally acceptable plea. And so Mr. Loomis is going to try to meet with you and go over the waiver with you on Monday if you're going to be available.
All right, sounds good.
He's checking his calendar now.
Monday looks good, 3:45.
All right, so will you be there then, Mr. Loomis, at 3:45 to talk to? Why don't we make it a little bit earlier then?
Yeah.
So because his evaluation, what time do you get off work, or can you be available like at 3 on Monday?
Yeah, I can do 3 o'clock if that works for everybody else, or the other time 2:30. I think it was 2 o'clock.
Well, here's what I want you to do. I want you to have enough time to go over the waiver with Mr. Loomis, your lawyer, which is very, very important that you know everything that's in that how your life will be impacted. And then you can go to your evaluation at 3:45. Does that work for everyone?
Works for me.
Good here, Judge. Thank you.
Yes, Your Honor.
All right, so Mr. Bearden, you'll be at the Reno Municipal Court at 3 p.m. And where would you like to meet with him, Mr. Loomis? In the clerk's office at 3 p.m.?
The what? Whose office?
The clerk's office downstairs,
What?
the clerk's office at 3 p.m. There's a place for him to wait there.
Okay, I was thinking
Would that be-
perhaps the jury room and courtroom A.
Okay, all right. That's also on the first floor. You just go to courtroom A. And I don't know if the doors will be open, but I'll let the marshals know that you're meeting your lawyer, Mr. Loomis, and they'll let you in to courtroom A as an apple, okay? Do you have any questions, Mr. Bearden?
Just it was July 18th, 8 a.m.
Yes.
All right,
That's
it.
your sentencing date, right? And everything else is going to happen Monday at 3.
Understood.
Okay, you're released on your own recognizance.
Thank you.
Please keep in mind the conditions.
And Mr. Bearden, that was July 17th at 8 a.m.
All right.
We're gonna go 18
Thank
more
you, Ms.
minutes.
Massey.
We're gonna hit 3 hours and then shut it down.
The next matter I have is Jeffrey Benton Hensley, 24 CR 06822.
Yes. Yes, we should. I'm going to.
How you doing, Your Honor?
I'm good. Thank you, Mr. Benton Hensley. Thank you for your patience this morning. So, Mr. Benton Hensley, you were charged on May 28th, 2024 with domestic battery first offense. Did you understand the charge, sir?
I did.
All right. And is it your intention to enter a plea of not guilty and schedule the matter for trial?
I really don't know. I would rather talk to my lawyer one more time before I enter a plea.
Okay, well, we'll go ahead and ask Miss Massey to put Mr. Altum and myself in the waiting rooms while you discuss the matter or your decisions with your lawyer.
Thank you.
And if I could ask one question before that happens, Judge, they said no charges had yet been filed, and I have not seen a complaint in this case. And so I'm not clear that domestic battery was actually ended up being charged.
Yes, it was on the 30th. That's today. I have a complaint in my file, Mr. Loomis. If
Okay.
you'd like to have my staff send the copy of that complaint to you, I think that that's only fair. And so, Ms. Massey or Ms. Gonzalez, would you forward the complaint from Mr. Benton Hensley to Mr. Loomis so he can go over that with his client?
Yes, Your Honor.
I'll also forward you his criminal history, Mr. Loomis, okay?
Yes, I appreciate it.
I filed it after hours yesterday about 5:30.
Okay.
Thanks.
I'll be placing you both in the waiting room.
Okay, Mr. Hensley, the thing is, so they have formally charged you with a domestic battery first. That's an enhanceable offense. Meaning that there's mandatory penalties associated with the first. If you get a second within 7 years, those penalties go up. And if you get a third within 7 years of the first, it's state prison time.
Right.
And that's why it's important to consider this carefully.
Yeah.
What I will tell you is a lot of these cases go away by the time that the trial date comes around and they get dismissed, but not always. It depends upon who shows up.
Right.
And so, but if you can't make bail, then you'll have to wait in custody until the trial date is set or the pretrial conference for domestic battery is set, and which is usually 4 to 6 weeks out. So, that's a significant amount of time. I've got you as homeless and unemployed, though you're working with Integrity Staffing.
Yeah, I'm just waiting for my background to come back.
Waiting for your background to come back in. Now, Mr. Altum is going to send me your criminal history, which I have not seen.
Okay.
How bad do you think that is?
I have no felonies, none.
No felonies? Okay,
No
that's good.
domestics, no anything.
And so, who is Noelle cost to you?
My girlfriend.
Okay, so you guys had a dating relationship?
We did.
You said you got a 12-hour no bail hold at the moment.
It's over now.
It's over now. Do you have is there a bail listed for you at this point?
No.
No? Okay, so we can address bail to the judge. I'm gonna have to go to the email here and see if I can find that criminal history. And let me see if it's over there now.
I had some batteries dismissed like a year ago or so, maybe 2 years ago. They all got dismissed.
Okay. Yeah, I don't see it having shown up here in my email yet. Okay, it's not in my email as of yet. You told me you've been in Reno for 10 years. You have no other charges pending. You
No.
had a couple of batteries that were dismissed outright, or
Yes.
did you have to?
They got dismissed. Well, I did 6 months, I think, on the gross misdemeanor or whatever. But that's about it.
When was that?
That was, I believe, last year or the year before.
Okay. What was the charge?
It was battery, I think. I can't really remember.
Okay, well, that is not good. Do you have a place to stay at the moment?
No, I'm homeless.
Do you have a phone?
I do.
Yeah, you have a working phone number that they can call you.
Yes.
Okay, well, I'll tell you what, Mr. Hensley, frankly, I don't think you're going to get an OR release. But you might be able to get some kind of bail. Do you have any assistance on the outside that might help you make a bail?
Not really. I got brothers and sisters I can possibly ask, but that's about it. I don't really have no income or no help or anything.
Okay. Well, so your choices are today, no contest plea to the domestic battery first, or not guilty and try to make bail and wait for that domestic battery pretrial conference.
I guess I want to try to make bail.
Okay. That's my recommendation is try to plead not guilty and try to make the bail.
Yeah, because I
If you,
I was extremely intoxicated when this happened. That's my issue is alcohol. I never had an opportunity to do alcohol program or anything like that. So I would try to want to do something like that. Like I have no recollection of this incident whatsoever. I just woke up here in jail.
okay. Well, that also is not good, but they could impose conditions as a on a release from bail that you do daily testing for alcohol and drugs, or maybe not that frequent. They have a sober 24 program where you have to call in every day and you're subject to random testing.
Right.
They might require that you carry a handheld alcohol detection unit, something like that. Those
Okay.
things all cost money.
Okay.
So but we'll make the pitch.
Okay. So what do I plead?
Not guilty.
Okay.
If it turns out that you cannot stay in custody up until the time of the conference, you can always ask to change your plea somewhere down the road.
Okay.
Okay?
Yep.
All right, I'll let her know we're ready to go.
Okay.
Michelle, can we bring everybody back in?
Yes.
All right, Mr. Loomis, have you had adequate time to speak with your client this morning?
I have had time to talk with them. It's been adequate time, yes.
All right, and what is your proposed plan of action, sir?
We are going to enter a not guilty plea and ask for bail consideration in light of the fact he hasn't had bail up until just recently. He was our 12-hour hold.
Okay, all right. Is that a correct statement, Mr. Benton Hensley?
Yes, ma'am.
All right, sir, I'll go ahead and accept your not guilty plea. We'll schedule a matter for trial. Can you afford your own counsel?
No, I cannot.
All right, I'll appoint a legal defender to represent you. May have a trial date with the legal defender first before we discuss bail.
Yes, Your Honor, that would be a domestic violence pretrial conference set for July 23rd at 8 a.m. And they have not assigned legal defenders as yet, so he'll have to check with the court.
All right, we'll go ahead. Hopefully, the legal defenders. So, Mr. Benton Hensley, your trial date will be July the 23rd at 8 a.m. in the Reno Municipal Court, which is located at 1 South Sierra Street in Reno, Nevada. You're going to need to be there. We will assign, I have assigned a lawyer. So Mr. Loomis is one of 5 or 6 counsel that we have in our queue of people who represent legal defendants charged with serious crimes. So he or one of the others will be assigned to your case. They haven't made a decision as to scheduling yet, but you will be provided with that information. I will order that you make contact with whomever you are assigned to be represented by, okay?
Yes, ma'am.
All right, sir. And as to bail, bail has not been set as yet. Mr. Alton, you wish to be heard as to bail?
Yes, thank you, Your Honor. City's going to recommend a little higher bail than kind of the standard schedule for a domestic battery first offense. We're going to ask for $6,000 bail. He scores a 10 high on the risk assessment with misdemeanor and felony convictions. His recent criminal history in the last 3 or 4 years includes batteries and other crimes of violence. It includes failures to appear on felony cases. In December 2022, was arrested on failure to appear on a gross misdemeanor crime. On that same day, he was arrested on a failure to appear on a felony crime. He had a battery by a prisoner arrest in 2021 with a resisting arrest, pled to a misdemeanor, several counts of battery, I'm sorry.
More than he admitted to.
And there's no
Are those convictions or arrests, sir?
Well, looks like the misdemeanor batteries were dismissed, and then there was a gross misdemeanor conviction that has no disposition. There is a numerous other battery and trespass or arrests with no disposition that I see. Increasing the likelihood of conviction, which is one bail factor in this case, are that at least one of the security officers saw the defendant punch his girlfriend victim in the face. At least once. So higher likelihood of conviction, history of violence, a higher risk assessment, failures to appear, city's recommendation is 6,000 and no contact with the victim.
And the victim's name, sir?
1 second, Your Honor.
Noel Cost.
That's right. Noel Cost with a K, K-O-S-T. Your Honor, also, I'd just add, in going through the probable cause sheet, Mr. Benton Hansley was also reported to have been belligerent with the officers, calling them some derogatory terms for white people.
All right, Mr. Loomis, you wish to be heard?
Yes, Your Honor, thank you. Mr. Benton Hensley has been in Reno for 10 years, he reports. I appreciate that Mr. Alton was sending me the criminal history. It didn't come by the time I was through talking with Mr. Benton Hensley, so I haven't seen it. Now, what he has reported is that he'd been arrested for some batteries, but there were no convictions. And he did do something on a gross misdemeanor, which I'm not exactly clear what that was. He's homeless, but he's also unemployed, but he has a application in with Integrity Staffing for temporary work, and he's waiting to hear from the background check. They're doing a background check on him, so he's waiting to hear how that comes out. So I would ask the court to consider a 2,000 bondable bail rather than the 6,000.
So, Mr. Benton Hensley, thank you, Mr. Loomis. Where do you live?
I just be out. I don't really have a place to stay. I'm just literally on the streets.
Okay.
If I could add one thing, he does have a working phone.
Okay, that's good to know. All right, well, I consider this to be a serious offense. I'm going to set bail in the amount of $4,000. That's going to be bondable with the following conditions, Mr. Benton Hensley. That is that you obey all laws, you have no alcohol or drugs without a valid prescription, including marijuana, and that you have no contact with the victim, whose name is Noel Cost. You know what no contact means, right?
Yes, ma'am. None whatsoever. Not even through a third party.
That's correct. No
Yes.
social media, no going by their home or work. So if you're able to bail, and you certainly can bail on this if you want to post a bond, but please keep in mind that I expect you to be back at the Reno Municipal Court on the date I've given you. And we'll give you a lawyer so you can make contact with them as soon as that lawyer's assigned, okay?
Yes, ma'am. And bondable means 10%, right?
That depends on the bail bond company, but yes,
Oh.
it's some percentage, yes.
Yes, ma'am. Okay.
All right, thank you, sir.
Thank you.
Your Honor, I missed if you had ordered any testing.
And are you requiring testing? You want to put him on some supervision? We'll put him on medium supervision. I don't recall if there was alcohol involved in this offense, but what do you think, Mr. Altum? I'll give you the opportunity to respond.
Your Honor, just 1 second. Let me see if the risk assessment. I'm not sure the risk assessment said anything about substance abuse, and I don't recall seeing anything regarding any intoxication in this case specifically.
All right, based upon the fact that this is a violent offense and he has some history, I'm going to put him on medium supervision with testing. All right, the next matter then is, and thank you, Ms.
All right, guys. I said that last one was the last one. We've got a minute left to kill, and I think that's a perfect time to give Ava some treats. Don't you, Ava? Ava, come say hi. Come give Palmy a smile. Come on. It's time to give Palmy a smile. Say, love you, Palmy. Yep, bedtime snacks for Ava. We do love you, Tony. All right, guys. We made it to the 3-hour mark. Yay! And I'm now going to go to sleep. Thank you all for coming out and hanging out with me and Ava and the kitties. It's been a lot of fun. We had our double feature Sav sit, and now we had our Reno Municipal Court because Rocky Lennon requested it. I know. I was watching the timer. It's now 3 hours and 44 seconds. So I am an overachiever. Good night, everybody. I love you all. Be safe, be well, sleep sweet, and much love.